Okay, good morning, everyone. It's now about 10:15, I think, on the 28th of June, and time to open the public inquiry. As I said, I'm going to cover some introductory matters so that we can get some business done, at least this morning, for the time we have. Can everybody hear me okay? Yes? Can people in the public seating hear me okay? Good, great. So welcome everyone to the inquiry in relation to the application by CWL Energy Limited for consent under Section 36 of the Electricity Act 1989 and a direction under Section 57.2 of the Town and Country Planning Scotland Act 1997 for the construction and operation of a 45-turbine wind farm and associated infrastructure at land west of Castleweary, Forside Community Wind Farm, Hoyk. Now, I intend to refer to it as the Forside Wind Farm here on. Hopefully that's okay for everybody. So my name is Claire Milne. I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division, and I've been appointed by Scottish ministers to consider this application and report my findings and recommendations to them. As a result of objections to the application from Scottish Borders Council, Scottish ministers decided that an inquiry should be held into the proposal. Objections have also been received from Dumfries and Galloway Council, Historic Environment Scotland and the Ministry of Defence, and from a number of community councils, the local MSP, a local community representative group and other individuals. So I haven't listed everybody there, but there's a number of people that have been involved. The inquiry will take place through oral sessions using both formal inquiry and more informal hearing procedures. The main purpose of these oral sessions is to make sure that I understand the positions of parties on each of the specific topics where further evidence is considered necessary. Where there is a dispute between parties, I need to be clear on the reasons for that dispute. This is so that these matters can be clearly set out in my report to the ministers. So before I ask parties to introduce themselves, I just want to cover a couple of things. I want to highlight that the inquiry session dealing with the Eskdale Muir seismic array, which was due to take place next week, has been postponed. It's primarily due to the absence of an agreed statement between the parties, and there was an amount of correspondence between the parties just in the last week or so. Insufficient time available to complete the outstanding work necessary to narrow the scope of the issues in dispute. And I took a decision on that, I think, in the middle of Tuesday of last week. No date has been set to reconvene the session, but I will liaise with the main parties and ask for updates and progress on the matter following the inquiry. So I don't want to get into the details of when that session might take place in this particular discussion today, but it will be a matter that I'll pursue after the inquiry. I've also been informed that the witness for the landscape and visual impacts inquiry session, which is due to take place over the next 2 days, Ms McDermott has contracted COVID and therefore is not able to take part in person. We can talk a little bit more about the options there when I talk about the days coming, but it really is a matter for whether we can get the technology working, really, and that's really the test that I want to try today and the determining factor on that. So could I ask those present to introduce themselves, and I'll start with the applicant, please.
Yes, good morning. Then my name is David Hardy, that's Hardy. I'm duly qualified as a barrister and a solicitor, but for present purposes, counsel with Squire Patton Boggs. We're planning lawyers based in Leeds. To my left, Mr. David Bell, who's going to be dealing with planning policy, and then Mr. Keith Campbell from Instructing Solicitors, and then client at the end on my far left.
Okay, thank you. And moving across to the council to my right, Mr. Armstrong.
Good morning. My name is Douglas Armstrong. I am Queen's Counsel and a member of the Faculty of Advocates, and I'm instructed by Dumfries and Galloway Council. To my right is Chris McTeer, Senior Planner at Dumfries and Galloway Council, who will be giving evidence today. And to his right is Laura Whitelaw, Solicitor with Dumfries and Galloway Council.
Thank you. And Scottish Borders Council.
Good morning, ma'am. My name is Ron Kirk. I'm a solicitor with Scottish Borders Council, and to my right is Scott Shearer, who is a peripatetic planning officer with the council, and he will be dealing with the hearing session today.
Thank you. And I understand I have Mr Campbell representing Forsyth Community Group.
Good morning, ma'am. I'm John Campbell. I'm a Queen's Counsel at the Scottish Bar, and I'm representing the Forsyth Community Group. I have with me on my right Christopher Ford, who is my first witness in this session, and to my left and behind me, Miss Yvonne Jackson, who is the organiser of the group.
Thank you. Let me just note these names down so I'm clear who's sitting in the room. Are there any others joining us here that are not directly involved in the hearing session on planning and energy policy? So I understand people are sitting at the back are all members of the public or parties that are just observing today. Okay, thank you. I held a pre-examination meeting on the 23rd of February 2022 as a means to guide the procedures for this case, and this can be viewed on our webcast library, and I produced a detailed note of the meeting and an annex setting out what was agreed at the meeting. There was a small update to that annex following the publication of that notice. I've also visited the site on an unaccompanied basis in April, and this visit included a number of viewpoints, the nearby settlements and journeys taken along the A7 and the B709. I intend to undertake an unaccompanied site inspection to the Borderlands Museum in Teviot Head on the 2nd of July. I think that's been arranged with Mr Moffat. I also intend to hold an accompanied site inspection on the 12th of August. Now, I'll ask the applicant to arrange and draw up the itinerary for that. You will all be invited to attend, and you're able to comment on the itinerary if there are particular features and viewpoints that you would like us to visit on the day. But I'd like you to bear in mind the overall time that we have available for that day and the features that maybe we can get round in one day available. Just looking at the applicant on the site inspection, I'll be in touch to arrange how that might be. And have you had any thoughts initially about how that site inspection might take place?
We've had an internal discussion. We will suggest an itinerary and work with the other parties to do that. Do you mean practically in terms of vehicles?
Not the practical arrangements, but really just roughly do you think that we'll have enough time to get round some of the viewpoints that you would like me to visit?
Yes.
Okay. So you will be aware that this inquiry will be filmed, and we have the capacity here with the cameras. You'll see 3 cameras that are available in the room. And then it will be webcast live on our webcasting site. So Graham to my left is organising all of that and will be available the whole time that the inquiry is happening this week. So the video recording will be retained on our website, and I think it's for 12 weeks, and after the application is determined. By taking part, you are consenting to being filmed and to the use and storage of those images and sound recordings and any information contained in them for webcasting and training purposes and for the purpose of keeping historical records and making those available to the public. Are there any objections to that? Okay, thank you. So just moving on to the format of the inquiry and any housekeeping issues. I anticipate starting each day at 9:30 a.m. and running till about 4:30. And we can be reasonably flexible on that depending on how matters are progressing and where we are in terms of witnesses' evidence. Participants should be ready to join the meeting 15 minutes before it's due to start. The exception to this is the community issues hearing this Friday, which is due to take place at 10 a.m, and also the sessions taking place in August, which are to be virtual, so we would start them at 10 a.m. Around an hour would be allowed for lunch. For virtual sessions, what we tend to do, and we've run quite a lot of virtual sessions now in the DPA, we tend to have shorter sitting days because it's quite tiring staring at a screen for long periods. So we'd start at 10, have a couple of hours, a good break in the middle, and then run for another 2 hours in the afternoon. So it is generally shorter days, and we would fit the breaks in around the kind of natural process of how the evidence is being presented and any subsequent questioning. When virtual, just 1 second, I think I might have had a connection. Just 1 moment. I'm not holding my breath on this one. Let's just see. Okay, I'll just let that run. When virtual, the witness is expected to remain on the screen with their video on for the duration of their evidence-giving session, excluding any lunch and formal breaks. So just so you're aware, it's a slightly different procedure, but I can brief parties on that when we come to do that. The inquiry documents are available as a memory stick on a laptop reviewing the inquiry. Now, I haven't set that up today because I understand people have access to it, but for Friday's community issues session, there will be a laptop set up with all the documents sitting already loaded. Now, it's a possibility if people need access to documents today that can't access that via the internet, that they could use that. I'm just wondering, Graham, if that might be possible as a backup. Any views on that, just if we have difficulties?
Well, I certainly need access. I don't know how many other people do. I'm not sure how feasible that will be.
It is just the one laptop, so it will be restricted to, yeah. In advance of the inquiry, the council's also made the documents available to view electronically at their offices and local libraries, I understand, but I don't think that has been taken up by many people or anyone who's viewed the documents, but it was certainly something we made available. In the COVID restrictions, they're continuing, I think, till September of this year, so it wasn't necessary a requirement for us to put the documents in hard copies available. So that's the arrangements as I understand them. They're also published on the DPA website under the case reference. Now, I understand the applicant has set up a collaboration site which contains the inquiry documents as a supplementary resource. So it doesn't replace what we have on the DPA website, but it's there as a supplementary resource, as an alternative way to access and get available documents to view them. So the parties may require to use smartphones, as we know, this morning, or other communication devices during the inquiry and hearing sessions. That's fine, that's acceptable, but they shouldn't be audible, so please silence all your phones. And parties are reminded that witnesses should be not included in such communications. So just touching on where we are with COVID-19, so all teams must adhere to the Scottish Government guidance that's in place at the moment. So I think I sent a note out to everybody to indicate that when you're moving around the building in here, in the circulation areas, please could you wear a mask? When you're seated, it's fine, you can take your mask off. Please try and keep roughly a metre apart, and we've set up the room to enable you to do that. If anybody is taken ill at any point, please could they let us know as soon as possible. However late in the day that may be, send an email so we know, and we'll see what we can do in terms of making alternative arrangements. For the virtual sessions where parties are operating from a shared office, please make sure that you maintain physical distance as well. This was particularly an issue when we were running lots of virtual sessions, so you're still operating in the DPA guide under DPA guidance. If I'm in any doubt the above advice is not being followed, it may be necessary to adjourn the inquiry, so I hope that won't be unnecessary. Finally, on housekeeping matters, just to let you know, presuming the fire escape, Graham, is out those doors, out into the side. Mm-hmm. And the toilets, both ladies and gents, is to the right-hand side in the corridor. So I'm just going to talk a little bit about the inquiry programme now. And it can all be viewed. I produced a one-page inquiry programme that's been placed on a website, I think sent to the main parties, and it really set out the kind of what I was thinking about the arrangements for the programme itself. So over this week we have one inquiry and 2 hearing sessions planned to take place. I then intend to assist the appeal. And this is due to the availability of parties for the Historic Environment Cultural Heritage session, and that was discussed at the pre-examination meeting, so the inquiry will be assisted in that interim period. And it will reconvene in August when the Cultural Heritage session is taking place. So we have a hearing session intending to take place on planning and energy policy today, so that will take place and finish today. And then tomorrow and Thursday we have inquiry sessions on landscape and visual impact matters. Starting at 9:30, that would be tomorrow morning. And then on Friday, as I said, there's a community issues hearing taking place, and that will be at a different venue in the Buccleuch Centre in Langham, and that's starting at 10 a.m. As I said, the inquiry session on the seismic array will no longer take place next week, and it may be necessary to assist the appeal again until that can take place. In the week commencing the 8th of August, we have one inquiry and one hearing. These are to take place virtually. So we have an inquiry session on cultural heritage, which will commence on the 9th of August and run for 2 days, and a hearing session on conditions, which will take place on the Thursday, the 11th of August, and then site inspection on the 12th. Before I move on, are there any questions around any of the programming and the process that we've got planned ahead? Mr. Campbell, you have a question?
Yes, I have, ma'am. We did agree at the pre-inquiry meeting that the cultural heritage session in August would be a virtual session. Without making any proposals just now, are you wedded to that idea, or can it be suggested that it would be better if it were an in-person session? I'm getting a certain amount of, not pressure exactly, but questioning from behind me, not Miss Jackson, but others, that this being essentially a local session, it would be more satisfactory if it were conducted locally in person. So I just asked the question rhetorically for the moment, but I would like you to consider that if you wouldn't mind.
Okay, I hear the question. I'd just like to hear from other parties what their views are on. It's been some time since February when we had the pre-examination meeting and discussed, and at the time COVID restrictions were still in place at that time, and it was felt that that was a reasonable approach based on what I heard at the pre-examination meeting. Has there been any thoughts, changes, views to that? Can I ask from the applicant first?
Yes, we want to stick with a virtual session. Arrangements have been made, professional diaries have been set, and I don't see any prejudice at all. They work very well, so I'd like to stick to the timetable, please.
Okay, thank you. Mr. Armstrong?
Again, ma'am, arrangements have been made for it to be for the team to do that session during by virtue a virtual session rather than in person, and that would be the preference at this stage.
Mr. Kirk for the Scottish Board.
Thank you, ma'am. I don't think our position differs from the applicant or the Dumfries and Galloway Council, but obviously if there's a flavour for it to be moved to an in-person session, then we would be able to accommodate that.
So just so I'm clear, you don't have a view either way?
Yeah, I suppose in essence what I'm saying is we're relaxed either way. Yeah.
As I said, it was back in February when we discussed this, and COVID restrictions still in place. I don't think we're out the woods, certainly yet, in terms of the difficulties, as you can see, that we're having today as well, over the next 2 days with a witness that can't be available. I would be worried, I think, of moving it to an in-person inquiry at this stage, given the uncertainties and the number of cases that are rising in Scotland particularly. My preference, I think, is to keep it as virtual. Mr. Campbell, can I just ask, you said you're under a little bit of pressure from parties.
No, I did use the word pressure, but I withdrew it. It's simply what might sound like a bit of a cliche, but a local session is something for local people. And people are more familiar, certainly in this part of the world, with a meeting which takes place virtually. And I detect amongst those to whom I've spoken and who will be taking part that they would prefer to speak to you person to person rather than on screen. But it's a preference, it's not essential. I hear what everybody else is saying, and so if I could leave the matter there for the moment, ma'am, unless something else happens, I won't raise it again.
Could you turn your microphone on? Thank you. Okay, thank you. Obviously, the other party, which is the representatives for Historic Environment Scotland, are not here today, so they're another party to that particular session who would. Obviously, I heard their views from them, and I think their preference was for virtual. Thank you for your comments. I'll have a think about that, and I will make a ruling on that if it changes from the current arrangements after the inquiry.
Thank you, I'm obliged.
For those who are not familiar with the inquiry process, the normal sequence is as follows, and probably most of you are, but I'll just run through it just for the benefit of those that aren't. So the advocate or solicitor introduces their witness, who gives their evidence in chief, drawn from their precognition and the relevant inquiry statement or report. In this case, we have both inquiry statements and reports in some instances. The witness is then cross-examined by the opposing party. The reporter then may ask questions of the witness, and the witness may be asked some further questions by their own advocate or solicitor, referred to as a re-examination. When the evidence on all the topics is concluded, parties will have the opportunity to make a closing submission in writing. We would do that in writing generally. That's the normal process rather than orally. The timescale for this will be agreed usually towards the end of the inquiry. Now, I have penciled in some dates for closing statements. I think we will discuss them after each session because it probably makes sense to do so, given that timetable has changed a little bit in terms of what's happening with next week not happening, and we've got to assist in between. So I think we'll leave the discussion of that till the sessions themselves. For the inquiry sessions, precognitions are generally taken as read. This is really to save time at the inquiry and also really to get into the detail of the inquiry cross-examination itself and witnesses' evidence. It is therefore expected that cross-examination will focus on those essential matters that are in dispute. As I've said, I've used that word quite a lot, and that is my main focus. There will be a lot of evidence, I'm sure, that parties and witnesses will want to hear, enable me to hear or want me to hear. But it's the key to my considerations and the time that can be best spent and efficiently at the inquiry is to focus on those matters that are in dispute, and that's where my concerns will be. I may intervene if I consider that the questions or answers are straying into matters that do not need to be included in my report. So in contrast to inquiries, hearings are less formal. These are discussions involving all the relevant participants and are chaired by the reporter. And I've issued the agenda for the first 2 hearing sessions, and that you'll have copies of that available. The format of the hearing session is a structured discussion, so it's not a free-for-all in terms of people being able to speak. It will be managed, and I will lead that discussion based on the agenda that I've circulated. And this, in turn, has been based on the hearing statements that the detailed hearing statements that people have put in and any documents that supported those. I shall lead the discussion by starting each item of the agenda with a question to one of the parties, but I also will invite others to respond also to that particular matter, because I appreciate that people have raised a number of points around those general questions and topics that I've set out in the agenda. This will probably lead to a further exchange of views, so we'll manage that process as we go through. But when I feel I have sufficient information on a particular topic, I will move it on to the next. The purpose of the hearing session, just for everybody's benefit, is not to persuade me of your point of view, but to help me make sure I understand the respective positions of the parties and where there are differences for those reasons, and so that I can clearly set these out for the Minister in my report. So in addition to the evidence considered through the inquiry and hearing sessions, my report and recommendations to ministers will also consider a range of other matters raised in consultation responses, written representations submitted to the Energy Consents Unit, and the further written submissions that have been made as well. So the details of all this can be viewed on our website. So that's my general conclusions. That's my general introduction concluded. Before I move on to the hearing session and we can discuss how the technology is working at this stage, are there any questions on the procedural matters? Okay, nothing further that's been raised. And any other matters anybody wants to raise at this point? Okay.
I beg your pardon, sorry, being a bit slow there. Could I ask you at whose behest next week is to be adjourned? Next week's hearing on the Delmuir seismic array. Sorry, I hope the question's clear.
Yeah, that's perfectly clear. It's a bit of a mixed response, I would say. I've had information, emails from the applicant and from the Ministry of Defence. There was a request by the applicant, as I understand, to postpone the inquiry and for a period of around 3 months. And the Ministry of Defence came back and indicated that they would like it to proceed, but also that 3 months certainly wasn't going to be long enough for the matters that need to be looked into, and perhaps 6 months or more. So all of this information was put to me. So I understand from the applicant also that the MOD did consider postponement as well for a 6-month period. It was something they were also looking at. So I did feel that both parties had some way to go on the whole issue.
Thank you. That's reassuring. You'll appreciate for those not involved in those sessions, there may well be a cost question, but I'll leave it just now. Thank you.
Any other matters at this stage? Okay, thank you. Yeah, okay. As I said earlier on in my introduction, we have an issue with one of the witnesses, Miss McDermott, sorry, who can't make the, on behalf of, is it Dumfries and Galloway, Scottish Borders Council, apologies, Scottish Borders Council, who's unable to make the in-person sessions. Now, there is a number of options we can look at. The first option potentially is that we could postpone the session completely. I'm reluctant to do that. It's one party and amongst everybody's made arrangements, and I don't want to disrupt proceedings and arrangements that people have made. But that is an option, and we reconvene that session at another date. The other option is that we continue with an in-person session. Miss McDermott would then watch from home, presumably, which so we're webcasting it, and then we have a later session involving her evidence. Again, it's not my favourite option, my preference, because I think it's important that they are involved throughout the whole process, and it makes a very disjointed inquiry session dealing with those matters. My third and preferable option is that we look at a hybrid. Now, we talked about hybrid as being a potential option when at the pre-examination meeting, and we explained at the time that the technology that we had to enable that to happen wasn't particularly good or able to enable us to do that. But we've had quite a lot of experience since in our own offices of running meetings in a hybrid manner. So hybrid is basically where some people are in the room, they all have a laptop in front of them, and anybody who's not available is able to connect through their own laptops from a remote location. Everybody looks at the screen, they don't look at each other in the room, they look at the screen, and basically you operate it like a virtual session. But some people are present and some people aren't. The audio for those particular sessions, we have what's called we call it a mothership, and it sits in the middle of the room, and it's got red lights on it, which is why we call it a mothership. But effectively, it picks up all the audio in the room and projects that in, but it also picks up anybody speaking remotely as well who's on the call. So is it a Teams call, as I understand? Yeah, it would be a Teams call. And it works quite well, providing you can get a good connection. And that's what is my worry at the moment, and that's why we've always worried about using it in certain remote locations. It works well in our offices where we have good, strong connections. So it all depends on how this works out today, but I would like to hear your views on that, or any other option that I haven't considered as a possibility as well. So I'll start with the applicant, Mr. Hardy.
Yes, a number of points. I actually had exactly this experience last week with a landscape consultant who tested positive for COVID on the morning, and there was grave difficulty in converting the physical event into a hybrid event when the council tried to use an omnidirectional microphone. It simply didn't work, had to be abandoned, and in the end people dispersed, in fact, back to hotel rooms and just went on to Teams with headsets. So that's first, that's a technical point, but a very real experience last week. And omnidirectional microphones, you have a central microphone in the room, particular difficulty with evidence in chief, and there's, I think, a disconnect sort of speaking into a microphone. It's much easier having it as a headset on a one-to-one with it on a Teams call if that's what you're going to do. So if it was remote, that would be my preference. Second thing is that, of course, it isn't just isolation. It's about how the witness is feeling. And if there's a positive test yesterday, it's going to be day 3. Fortunately, I've not had COVID, but for those people who have, that foggy-headedness is a symptom which seems common. So it all depends on how the witness feels. And I think it would be, it's not my witness, but I would be unhappy about continuing if they did not feel fit and able to do the session. So that probably is going to dictate the pace. I don't, ideally, the client does not want to postpone the entire session. There is an option which I spoke to my learned friend about, which is putting back the SBC witness until the day that we do conditions. So that would be in August. That would be a remote session. That is not ideal because you are splitting up the landscape evidence and having a month or so or 6 weeks in between. That is a possibility. I think out of all of those preferences that you list, first we've got to know whether or not the witness is fit and able. If the witness is fit and able, then my preference is to break out and do this on a full Teams format, not to worry about some sort of setup with an omnidirectional microphone. You just do it on Teams. I don't think we all need to be in this room. We can organise ourselves however we think fit. I suppose the final factor is this: there needs to be strong Wi-Fi for any type of remote event. If there is a risk of that not being strong enough, and I have to say my connection I've got on and then it's just gone off again, it is very, very unstable. It's not appropriate to have to listen when people can't hear properly and the signal breaks down. So if it's going to be a remote event, I would like that to be on Teams with individual headsets, but we've got to find places which have got stable Wi-Fi.
Okay, a couple of things there. Yes, absolutely. You know, having had COVID myself, I know that you don't feel particularly well for a number of days, and it does affect people differently. And I certainly wouldn't want the witness to be compromised in any way or feel under any pressure that they're having to give evidence when they're not 100%. The second point you make about the IT connections and the difficulties we may have, is there a possibility that if we did run it on a virtual basis, effectively as a Teams call, that if the Wi-Fi is not good in here, that you could take yourselves to somewhere where you would get better connections?
Yeah, well yes, and I mean, I think Mr. Bell said your Wi-Fi in your room was okay. I mean, it's a little bit odd, but we could all go back to our hotel rooms. It's not ideal. I don't know whether there is another function room in the hotel, whether we could split into 2 or 3 groups, maybe on a team basis. I don't know whether that will overwhelm the infrastructure in the hotel, or indeed whether or not there is a third-party venue. There may be another hotel where we could organise it and we could try and make some investigations. I know there are other hotels in the town where if we could take a meeting room, we may be able to share the burden on the IT. None of it's ideal.
I think there are definitely difficulties in this room. I don't know if there are difficulties across the hotel as a whole, and that's an unknown at the moment. Okay, I bear that in mind. I'm just going to ask others to come back. I'll go to the councils first, then Mr. Campbell. Mr. Kirk for.
Thank you, ma'am. Yeah, picking up first on Mr. Hardy's point about how the witness is feeling. She was certainly at work yesterday, but I don't think she was feeling 100%, and she was certainly speaking with a croaky voice. Now, also, I haven't touched base with her today, so I don't know how she's feeling today. I might be able to gauge that later on. And obviously, yeah, as Mr. Hardy has recognised, there are difficulties with the Wi-Fi. I mean, it may be I have no difficulty with her evidence session being postponed until the conditions session in August, if that was felt to be the best way forward. I appreciate it's not ideal. I'm not quite sure Mr. Shearer and I would go to find that there are council offices in Hoyk. It might be that we'd be able to accommodate something through the council offices in Hoyk tomorrow, but I'd have to find out if a room was available.
Okay. couple of things there. I think it would be important that we do find out how Ms McDermott is today. If you could possibly make a call, and we'll see if she's feels up to it, and it will be really down to her whether she feels up to it, and that may dictate that a later session is perhaps preferable. Can I ask Mr Armstrong for Dumfries and Galloway?
Ma'am, out of the three options, the one that we prefer is the second option. We will simply not know until tomorrow, really, how Miss McDermott is feeling. She may feel better today, but again, there might be a relapse tomorrow. And I think the safest option is the second option, which I can't see really prejudicing anyone, because we can progress with all the evidence today. The witness, when she feels better, can then watch it, and the recording of it, and then we can perhaps, I suggested the date in August, because I suspect the condition session will not take the whole day, and we would have that additional time, say perhaps in the afternoon, to go through this witness's evidence. There'd be no prejudice to anyone, because obviously the Borders Council witness will have seen and heard the evidence, and everyone will have an opportunity to ask questions of that witness at that time. I think the third option, there clearly are a lot of question marks in relation to that, about whether people will be able to find rooms, whether the Wi-Fi works in everybody's room, if everybody is sort of going online at the same time, or whether there's other options within the town or elsewhere. And there's a number of question marks over that, and they will not be resolved until, I'd have thought, till tomorrow. And again, of course, there's the question over whether the witness is up to participating. Clearly, the first option I would say is the least desirable. Obviously, everyone's arranged to be here, and I would hope that the second option is the most desirable and attractive to parties.
Mr Campbell, do you have a view? You're involved in the sessions.
Yes, I'm in agreement with my learned friend Mr Armstrong. I don't want to say any more.
Yeah, clearly there are a number of difficulties with this, and I said there are two aspects to it. It's the technology and the ability to run, even if Mrs McDermott was here in person tomorrow, to be able to run that effectively, given the problems we're having today. And enabling everybody to get access to documents. Although, given the time we've got to get through a session today and to organise ourselves for tomorrow, it might be possible. And then there's the second matter of Miss McDermott's actual health and ability to take part effectively. I'm more kind of minded to moving keeping the session going in some form, and perhaps moving Miss McDermott's evidence to August. Are there any issues in terms of the prejudice that might afford to other parties? The general feeling was that there wasn't, but you felt, Mr Hardy, that there was?
The important thing is to get on. So it's not ideal. Just a couple of observations. When this has happened before, and it's a matter obviously for the council, there has been a feeling that there needs to be equality of arms. That is, that it isn't right that some people give their evidence virtually and other people give their evidence in person. That's not a point I make. It may be that it's something for the council to consider. I don't understand them to be making that point, but it is a consideration. Second point is, it is very disjointed. The landscape evidence is, it's one landscape, yes, it's in two administrative areas. 6 weeks or whatever it is a long time. Lots happens in that six-week period, and coming back to it, for a day is difficult. I don't say it's insurmountable, but it is problematic. And the third thing is a very different point, and that is if we were going to go with the option of August in terms of best use of time. I wonder if we were going to take a day and a half for landscape, whether we might be able to use the half a day to do the conditions session on Thursday. So that would leave the day in August just to concentrate on landscape. So I think if you're going to do landscape and then conditions, it surprised me at the Sanquhar Inquiry, for instance, conditions took a day. It was a long time because there were detailed points, and suddenly you get pressure on that third day. So if that were possible, and we were going to switch it to August, I think my recommendation would be to ask whether we could use that time to look at conditions this week.
Sorry, just so I understand, you're suggesting we use the time that would have been spent, the evidence for Mr McDermott to look at some conditions?
Because there may be half a day or so that would have been used for landscape evidence achieved cross-examination, but to use that time for conditions so that you're taking the pressure off that one day in August where we would be doing that evidence plus conditions. Because I think I was surprised how long it took at the last Section 36 to run through conditions.
Sorry, I should have taken that off. My concern is making things a bit too disjointed and jumping in and out of. Also, landscape and visual impacts, we have quite a packed agenda, really. If we start off tomorrow, we've got your witness, Mr Welch, covering the morning, any matters arising that come up as well before that. And then it was the afternoon session, I think, that we'd put in for Miss McDermott. So we've got that afternoon, but we can bring things forward, possibly. And then it was Dumfries and Galloway's counsel on Thursday morning, and then commencing Forsyth Community Group's witness Mark Steele, and then Mr Mundell. So quite a lot to pack in anyway in those 2 days, I think. Quite a lot of evidence, more witnesses I would normally have over those periods of time. It's possible. I'm not very happy about jumping about too much. And we don't have hearing statements for the conditions session. I know I have an agreed position, I think it is, on conditions, and a very long document, which I've still to look through in a lot more detail. I don't think I'm prepared yet to do a condition session.
It was just, I mean, absolutely, it's not ideal. It was to take the pressure off that day in August. That was my real point, because I can see us not finishing both the SBC evidence and conditions on that day. Now, maybe the solution there is to add, we have to look at another day. Of course, the Estelmuir session is to be in the future, so it could be that we deal with conditions at that stage.
I mean, it's possible. I'll let you come in just a second, Mr Armstrong. It's possible that conditions could be left to a much later stage, because actually, until the evidence on the seismic array is heard, it's possible that we could be jumping the gun in terms of talking about conditions. So I know what the outcome of that particular session is as well. So it's possible that the session for the 11th of August could pick up Ms McDermott's evidence on landscape and visual. Okay, Mr Armstrong.
Ma'am, I was going to suggest that because I think moving the conditions session back to Thursday, there's the problem, the additional problem that I think the parties are still in discussions about the conditions. I think the applicant has got our suggested changes, and we're waiting for a response from the applicant. So there is still a little way to go on that. I mean, I would anticipate that a lot of issues, certainly between the applicant and Dumfries and Galloway Council, will be resolved in further discussions. I don't think they'll be resolved by Thursday, because obviously we haven't seen the next version of the conditions, or the revised version. If there's a concern about the conditions and the Borders Council evidence being held on one day, then our preference would be for the conditions session to go to a later date, rather than being brought forward to an earlier date.
Okay, that sounds reasonable. I'm concerned about having a condition session in just in the next couple of days, if I'm truly honest. And I think it would be better to have it after we've heard all the evidence. I think it's a session that should come later on. So there's a possibility that we run the next 2 days without Ms McDermott's presence, but she's able to listen in if she feels able to listen in. She can also listen to the and watch the webcast after it's been published anyway, and get up to speed on all the evidence that was presented. And we move her evidence. This is just a suggestion at this stage. I'll ask for Scottish Borders Council's views on this as well. That we move her evidence to the proposed conditions session on the 11th of August. Mr. Kirk, could I just get your views on?
I'm content with that, ma'am. I have no difficulties with it.
In the meantime, could you just find out how she's doing, just so we can get an update and maybe just report that back later on today?
Absolutely, ma'am. I'll try and contact her during the lunch break.
Okay, is that agreed? Is that a reasonable response to how we deal with this at this stage?
I think so. Two things. Can I just be clear about running order then tomorrow, and also to confirm that that then would be a virtual session on the August the 11th? Yes.
Yes, I would intend that to be a virtual session. I think that's probably the safest way to do that at this stage. That whole week is planned as virtual, unless I hear what Mr. Campbell's been saying about requesting that in person. But as it stands at the moment, as agreed at the pre-examination meeting, that week was to be virtual. Yes. So all being well, over the next couple of days, we can run the landscape and visual sessions with the applicant's witness, Dumfries and Galloway's witness, Forside Community Group's witness, and Oliver Mundell, who's appearing as his own witness. And we can get through that in the next couple of days. We will, if we can, as much as possible, use the technology that we have available. I understand, we could run it as a Teams call, but I am worried about, as you suggest, Mr. Hardy, but I am worried about the connections that people have moving around in different locations, trying to get a team call set up in such short notice. If we can all come here tomorrow and we can see how the session runs this afternoon as well today, and see if we can get that running tomorrow, bring as much backups as you can in terms of mobile phones, USBs. We've got the spare laptop, spare tablet here that I can use, so that we can try and run this session as in the manner that we intended, which was in person, and do that as well as we can tomorrow. Does that sound a reasonable approach at this stage? Okay, everyone's nodding. Okay, thank you. Okay, I'm going to just take a brief, we'll just have a little break, if that's okay. I think, Mr. Campbell, you said that you'd asked for some coffee. It may be that we can get it, yes, possibly. And if people are having coffee, they can go and have a little break and a comfort break, and then we'll start off back with the hearing session.
Okay, I asked him to put it out at 11:30, so it's a little while, but provided you're not too precise about how long the break is, I'm sure that'll be fine.
I'm sure we can ask him to put the kettle on a little bit earlier. I'm going to do that.
Could I just make it clear, for the sake of my bank balance, that I'm not offering to buy coffee for everyone?
No, it's an important point. The DPA doesn't cover any catering costs in the hotel, so any expense that you incur while you're here, could you settle up with the hotel? They're on a tab, I think. What's the name of the gentleman in there?
He's called Matthew, and he's quite happy to set up a tab.
There you go. That's the best. That's the best arrangement. Okay, thank you. Right. Okay, can we just have a break until 11:30? Just next. Can we have 20 minutes? Does that suit everyone? Yeah. Okay. I'll see you back at 11:30. Okay, well, welcome back, everyone. I hope you've had a wee break there. What I'm proposing is 11:30. With the hearing session, we can break at various points that obviously once got through a particular question before we move on to the next one. So we will stop for lunch maybe between 12:30, 1 o'clock, something like that. We'll see where we are at that point. My Wi-Fi connection is dropping in and out. It's just gone again, but actually it was okay. So it's intermittent as much as I can say. Just see if you can get things, when you do get access, if you can just try and keep that access and open anything that you need to get open. So I issued an agenda for this hearing session dealing with planning and energy policy. And I intend to follow the questions in order. Any questions that you have, you can put them through me, that's fine. But I will move things on if I need to actually get the information that I need by the end of today. We'll see how the time plays out. We've got the rest of the day to complete this hearing session, which I think is ample time. And we can go into the afternoon for a fair while if we need it. So I'm going to just check who's taking part in this hearing session. Mr. Campbell, do you have a question before I ask?
Yes, I do.
Yeah.
Last week I sent you an additional hearing statement by Mr. Ford and a document on which I wanted to rely in, or I wanted him to rely in the course of his evidence. You rejected that, and of course I respect that decision. I'd just like to check that is still your position, ma'am, because it seems to me that it is right at the heart of what we're going to discuss. And so I would respectfully ask you if you wouldn't mind reconsidering that ruling. The document was sent to the other teams, so it won't be new to them. But, of course, I have to take your decision on it and respect it, and the evidence will be tailored accordingly.
Thank you, Mr. Campbell. I was going to come on to documents, but we'll cover it now. Yes, there was two actual documents. There was a document you provided which related to carbon calculator, and I think it's that one that you're talking about. Yes. I mean, this is a matter, as I said to you, that I raised in further written submissions. And in all fairness, the way that I consider that matter is to continue that as a written submissions procedure. I understand the point you're making, that it overlaps somewhat with some of the discussions we'll be having today as well. There's no reason why I can't take that written evidence and build that into my considerations, with also alongside the evidence I hear orally today. So I am sticking to that decision that I've taken. But it is highly likely that I will request further written submissions on that matter after the session.
To be absolutely clear, you're not accepting the additional hearing statement as a written submission. It simply isn't part of the inquiry evidence at the moment.
That's correct.
Thank you very much.
Well, while we're on documents, you submitted I think it was a statement that was read out by another, I think it came through on Friday, was it? Or was it on Monday? Apologies, I can't think when it came through, and I can't get access to my emails now when that was. So there is another thing that you've referred to?
Is that the minister? Yes. The document is a transcript of a speech by the Secretary of State for Business, Mr. Kwarteng, and it appeared on my desk, I think on Saturday. No, it can't have been. It must have been Friday, because I asked your staff to refer it to you then. I'm not sure that I have a clear answer, except from Dumfries and Galloway and Scottish Borders, both of whom say they have no objection to it being lodged. I'm not sure that you've ruled on it yet, ma'am, and we haven't heard from my friend Mr. Hardy or his clients. So that is there in limbo, really, waiting a ruling.
Yes, I've actually got the email here. So the Secretary of State made a speech last Thursday which you consider relates to matters under review in this inquiry. And I asked you to send that to me. I didn't have it initially sent, but I asked you to send that.
I kept it from you to begin with to see if I could find out what the other team's response was.
Okay.
That's why.
Now, I just want to, obviously I've had sight of that statement, that speech that was given. Could I ask the applicant if they wish to comment on whether that is appropriate for lodging at this stage?
Yes, we're quite relaxed. In fact, we say it's supportive of our position. So no doubt others will take a different view, but we're happy.
Mr. Armstrong, for Dumfries and Galloway Council, any objections?
No objection, ma'am.
And for Scottish Borders?
Likewise, ma'am, no objection.
Well, I don't have an issue with that statement, that speech transcript being submitted. So if we could submit that as an additional document, and it would be for Forsyth community groups policy document list, I understand, runs to document 39, so it would be document 40.
It would be document 40, ma'am, yes.
Yeah.
Thank you, ma'am. That deals with that. Much obliged.
Would you mind just giving me a moment while I've got Wi-Fi connection to just get that document? It's put in here somewhere. Just give me one moment. Okay, thank you. I've got that open now. So can I just check who's taking part in this inquiry session? I'll read out the names and please tell me if I've got this wrong. I've got 4 witnesses. So I've got Mr. Bell, David Bell, representing the applicant. I have Scott Shearer representing Scottish Borders Council. I have Chris McTeer representing Dumfries and Galloway Council, and I have Christopher Ford representing Fourside Community Group. There's no one else intending to take part in this hearing session. Okay. Are there any questions on the procedures? Anything you have any concerns about at this stage, or are you happy for me to go and lead and through the questions as set out in the agenda? Okay, on that basis, I'll now move on to my questions. So I've put my questions under a number of headings. And this is a kind of typical hearing agenda, I suppose, for an item of this, dealing with these matters. So it's trying to focus in on those issues where I see dispute, perhaps, between parties in their hearing statements. But I've set some of it out as a series of kind of statements made by parties. But I will afford people the opportunity to come back on particular issues. Just give me just a second. Okay. So I'm going to read a couple of the first few questions out, and then I will ask parties to comment. So having read through the hearing statements, I've noted that Mr. Bell Mr. Bell on behalf of the applicant refers to a number of policy documents, and so do the other parties also refer to these documents. And I think there's general agreement of the actual documents, policy documents that are relevant to this hearing session. It's really about the interpretation and content of those, I think, is where there is some dispute. So there's a number of documents, including the Climate Change Committee's 6th Carbon Budget 2020, CD 1120 and CD 1121, and the Onshore Wind Policy Statement Refresh 2021 Consultative Draft, CD 8.5. And in there he highlights the support from UK Government and Scottish Government on substantially growing onshore wind to attain the targets by 2030 and 2050. He then goes on to talk about the planning balance, and Mr. Bell considers that there is a need to give relatively more weight to the seriousness and importance of energy policy-related considerations. He considers the amount of harm needed to justify a refusal of consent is now greater in each wind farm case than would be so without the net zero legal obligation. And he makes reference to a Scottish Minister's decision, WIN-170-2007. Sorry, I haven't got the name of that case. Strathy. Thank you. Strathy Wood. Mr. Ford, who is speaking on behalf of Fourside Community Group, argues that there is no energy or policy need for more wind farms. His comments, which include references also to the consultative draft policy wind policy statement, refresh, highlights a number of matters. And he highlights the potential for oversupply of electricity generation, with the only legislative control of these being Section 36 consents. He highlights the subtle shift in government policy towards onshore wind, the ambition for which can comfortably be met from consented sites, repowering and extensions. He raises the matter of barriers to deployment, which include the seismic array at Eskdalemuir, aviation lighting, energy market regulation, transmission charging and transmission capacity. And he raises another final matter. The balance of policy, in his view, appears to be shifting away from widespread consenting of onshore wind energy. So you've got a number of positions there. And obviously the councils themselves have been through these policy documents in their hearing statements and given me their views on the merits of those. And as I understand it, from Dumfries and Galloway's point of view and from Scottish Borders Council, they also are of the view, similar to Forsyth Community Group, that there isn't a shift in the direction of, and that's really, not been much change in the overall approach to wind energy at the national level. So I'm going to ask parties to come back on this. I'm going to start with the applicant and take their views, and then I'll take the opposing views from the other parties. So, Mr. Bell, would you like to talk through your evidence that you've given in your statement in relation to this particular issue?
Thank you. There's clearly quite a lot of evidence in my hearing statement. I don't intend to go through that in any great detail. What I can try and do is give a précis, a summary of some of the key points. In the question 2.1, there's reference to two documents, the carbon budget and the onshore wind policy statement refresh, but there are clearly other documents referred to. In terms of the UK policy position, starting at that level, one key document is the Energy White Paper, which is CD 11.019, and that's referred to in my hearing statement at page 62. And whilst that does set out that there will be substantial growth in renewables, and there's emphasis on offshore wind, there is reference to onshore wind and solar as key building blocks of the generation mix. I think that's page 38. So that's key building blocks of the future mix. And the sixth carbon budget, that's a reference document, so the Committee on Climate Change have set out their various scenarios, and in all the scenarios, it's about 30 gigawatts of onshore wind in those scenarios. I think there are various references to the UK planning policy position on onshore wind that Mr. Ford covers. He's right in saying that there is reference to community support needing to be demonstrated as set out in English National Planning Policy, but that does not apply here. In terms of the Scottish position, the refresh that's referenced in the question, that's the onshore wind refresh, is the latest policy position from government. There are clearly other documents referred to in evidence, but the leading edge government position is in that document, and it's worth referring to a few brief references. Firstly, I would say paragraph 1.2.2, the government is saying we must go further and faster than before. And there's reference to the substantial increased demand for electricity to support net zero and the expectation of a doubling in electricity demand. So that's looking forward to the way in which electricity will be greatly deployed in terms of heating, air source heat pumps, moving away from gas boilers and oil tanks in rural areas to electricity, vehicle charging, and all that activity. That future demand is also reflected in the sixth carbon budget and, importantly, in the white paper, where there's a very substantial increase recognised in the move to electricity. The second reference in the refresh I would highlight is at 1.2.3. Where at the end of that paragraph it says, our aim, this is the Scottish Government, is to maintain the supportive policy and regulatory framework which will enable us to increase that deployment still further, and that's onshore wind. And the third reference I would just highlight for the moment is 2.1.1 in the refresh, which states our demand for green electricity will increase substantially over the course of the next decade. This means that a consistently higher rate of onshore wind and other renewables capacity will be required year on year. So the applicant's position is that from a straight reading of the latest government policy document, accepting it's a draft, but it sets out the government's view, is that it's committed to substantially growing onshore wind. And if one looks back at the current in force onshore wind policy statement, it references onshore wind as being vital to Scotland's net zero targets. So, bringing that together in my evidence, what I'm saying is that the approach should be to accord great weight or significant weight to the energy policy considerations, but that's not an overriding matter that would clearly not be appropriate in any planning judgment. And that was really the approach that I set out in evidence to the Strathy Wood inquiry. And that, I think, is a helpful way of dealing with the matter. So that's in CD 15.031. So in the inquiry report, the Deputy Chief Reporter set out the position that in terms of the current planning policy documents, that there are recent changes to energy and climate change, to the energy and climate change position, in particular references made to the climate emergency, and consequently it would be appropriate to place greater importance or weight to the benefits of renewable energy in the overall planning balance. So that point goes into the balance, and the applicant's position, and indeed my professional view, would be that the proposed development would be acceptable in relation to existing policy. So that's not NPF4. I'm not bringing NPF4 into the position there. But clearly what is coming down the track in terms of NPF4 will further strengthen that position. So I'm happy to stop there as a sort of summary of what I think is what I've set out in the hearing statement. Thank you.
Thank you, Mr. Bell. Mr. Ford, do you want to come back on that?
Good morning, Ma'am. Yes, thank you. I'll look at the UK policy first, then the Scottish policy, and then make some overall observations on these points. Ma'am, in your notes you focused on the Climate Change Committee's remarks, and Mr. Bell's focused on particularly the 6 carbon budget, this 25 to 30 gigawatts of onshore wind capacity it suggests. We should look at that. This 20 to 30 gigawatts is really for the whole UK, not merely for Scotland. If you applied that 20 to 30 gigawatts proportionately to the Scottish population, that's equivalent to about 10%. That would mean Scotland needs to provide between 2.5 and 3 gigawatts of onshore wind in Scotland. We're obviously far beyond that at the moment. Even if you look at that 30 gigawatts on a proportionate land area basis, Scotland has about 32% of the UK land area. So the equivalent share of that is about 8 to 9 gigawatts. Scotland has already delivered that as well. So in terms of Scotland's contribution to that 30 gigawatts, it's already been delivered. It isn't really for this inquiry, but I suspect really what the Climate Committee's 30 gigawatt figure is actually about is gently trying to suggest to the UK government that it looks at onshore wind in England and Wales. We don't need to go into that right now. But if we look at the 30 gigawatts in its own right, it's actually not significant within the overall Climate Committee proposals. The key proposals for the Climate Committee are related to offshore wind, 40 gigawatts, dispatchable and flexible power, 50 terawatt hours, of gas, CCS and BECCS, which is a biomass equivalent of carbon capture and storage. And an increase in flexibility of the energy system using demand-side response, hydrogen storage. So onshore wind, in fact, is not terribly important to the 6th carbon budget. And accordingly, onshore wind actually isn't mentioned in the 6th carbon budget's list of deployment at scale. And even within the electricity chapter of the 6 carbon budgets, you'll see that it's very well down the list. In fact, it's hardly mentioned. Under Next Works to accommodate new generation, the Climate Committee mentions that other types of generation are required, but there's no mention of onshore wind. The Climate Committee suggests wholesale electricity market design needs reviewing to be better suited to net zero, and according to the Climate Committee, that means flexibility and minimising overall system costs, which is an important point we should come back to later on. That's because there are problems at the moment, and I would hope that the Scottish ministers are going to recognise those problems in this decision and possibly in other decisions as well. In any event, what the Climate Committee is proposing is not government policy. It is simply advisory. It is advisory to the UK government, and it's for the UK government to take up the proposals or not, as the case may be. So turning to the wider issue of UK government policy, Mr Bell suggests that UK government policy supports this proposal. Let me make it very clear, Ma'am, you asked for focus on differences between the parties. In my understanding, the UK government policy most definitely does not support this proposal. Mr Bell referred to the UK Energy White Paper. He managed to find the one reference that there is in it to onshore wind. It's a passing reference, in fact. As he says, it refers to a building block. I'm not sure what a building block means. I'm not sure whether it's something that you put into the wall as you're building the house, or building block is actually part of the foundations that you've the point where you start from for building the house. But if you look at the Energy White Paper across the board, what you see is a list of key programmes for the UK government. These completely ignore onshore wind energy. Onshore wind energy is not a priority for future UK energy policy. It's very much on the back burner. There are no detailed programmes for it at all. If we look at the UK government's 2021 draft overarching policy statement for energy, which is EN1, and the parts of it related to the draft for renewables, which is EN3, we see barely any mention of onshore wind. I appreciate, Ma'am, these may not be part of your document library because they are UK government policy and they're draft anyway, but they're an indication of direction of travel.
Yeah, I was just struggling to locate those documents. You went EN1 and EN3. Are they references that you're using, or?
They're the labels given to them by the UK government department.
Now I'll fill in any missing references in a note to you, if I may.
These overarching policies statements do for energy is to really take the Energy White Paper forward. As I say, when you get into the detail of it, you see barely any mention of onshore wind. When it comes to renewables under EN3, it has chapters on biomass and waste energy. It has chapters on offshore wind. It has chapters on hydro and pump storage. It has chapters on solar and tidal. But there is absolutely no chapter at all and no mention at all of onshore wind. It's a stunning omission. The UK government has substantial programs biomass, hydrogen, carbon capture and utilisation and storage. It's equivalent of that, so carbon capture for biomass, and lots of new nuclear. It also has plenty of solar power in its programmes as well. Again, absolutely nothing on onshore wind. You have to wonder why. You have to wonder whether this really means support for onshore wind policy within the UK. In summer 2021, the UK government set out its programme for transitioning the energy system to be fit for purpose for net zero. It's called the Smart System and Flexibility Plan. The
emphasis of this is to move away from the problems of intermittent power provided by onshore wind. The problems with this are highlighted in Figure 1, my statement at page 39, where it shows the periods where the wind is blowing and periods where the wind is not blowing. Sorry, page 31, yeah. This creates major problems for the electricity market, particularly here in Scotland. What the energy system needs is dispatchable generation which can adjust to daily and seasonal fluctuations in demand for electricity. Again, there is no role given in this document for onshore wind in Scotland. In fact, we need dispatchable energy production close to locations of energy demand. So, in other words, the main UK population centres. So really talking about, in GB terms, not just Edinburgh and Glasgow, but Manchester, Leeds, Birmingham, London, and the other areas across England. This recent UK government policy document is the British Energy Security Strategy. This shows the priorities for energy security will be delivered through, here's another list, new nuclear, offshore wind, solar, hydrogen and storage. This time offshore wind does get a mention. Onshore wind does get a mention. In Scotland, the UK government says it wants to see future projects, quote, ensure communities and landscape issues are considered, close quote. Offshore wind well down the priority list.
Mr. Ford, sorry to interrupt you. Could you move your microphone a little bit closer? We're getting a little bit of interference. I don't know if it's breaking up as you're speaking. Thank you.
Is that better? Thank you. Okay. Thank you. Importantly, the Energy Security Statement identifies problems with the overall energy system costs. This is equivalent to what the OWPS refers to, in other words, the Scottish Onshore Policy Refresh Statement calls barriers to deployment. The Energy Security Strategy says that in future CFD auctions, that's contracts for different auctions supporting renewable energy in the UK, these measures will be taken to, quote, incentivise renewables to locate and operate in a way that minimise overall system costs, close quote. That's on page 17 of the Energy Security Strategy. It also says there will be, quote, a review of electricity market arrangements on page 25. In section 3.2 and 3.3 of my statement, I have explained why these reviews are necessary. It is because essentially the excess of wind energy in Scotland is causing major problems because it exceeds both the amount of demand for electricity in Scotland and the transmission capacity between Scotland and England. Our productions 45 and 46, which are from the electricity systems operator, give much more detail, and I can expand on that if you want to.
Numbers 25 and 26.
So, which is our numbers 25 and 26 in the document list. Ma'am, you've accepted the B's statement, Secretary of State for Business, Energy and Industrial Strategy last week. The Secretary of State gave a speech in which he gave the energy priorities for pathways to decarbonisation and to enhancing energy security. He is obviously deeply aware of the cost of living crisis driven by rapidly rising energy costs. He gave a long list of priority measures to address this. This included retaining coal-fired power stations, at least over the winter and possibly longer, offshore wind, accelerating development, hydrogen, carbon capture, use and storage, and potentially a new offshore oil and gas leasing round, even the possibility of opening up onshore fracking in the UK, new nuclear, and reforming the electricity market. The list also included onshore wind in England, where there are local partnerships. That means where local communities support the proposals and get benefits from the onshore wind farms within their community. Since neither of these apply in Scotland, this proposal would not qualify for that. It is highly conspicuous that in the Secretary of State statement last week, there was a conspicuous omission of Scottish wind is not mentioned. Again, we have to ask why. In many ways, the Secretary of State is taking a throw in the kitchen sink approach to the current energy crisis, doing everything possible to minimise the electricity price shock. But despite that, Scottish onshore wind, in fact, any Scottish wind energy, is not being mentioned. Scottish onshore wind energy is not a priority, and it doesn't get a mention in the Secretary of State's priority list. Clearly, Scottish onshore wind is not significant for the UK government. As I understand it, the only relevance of Scottish wind in terms of the Secretary of State's priorities is actually in terms of, quote, reforming the electricity market, close quote. That is because the current market and the volume of onshore wind energy in Scotland has unbalanced the whole of the UK's energy system. The oversupply of wind energy in Scotland has resulted in a high level of curtailment, where wind farms have to be turned off and very expensive constraint costs arise. According to the electricity systems operator, these costs have grown eightfold in the last 10 years, entirely because of the huge growth of onshore wind in Scotland. Because of that, these costs are now unsustainable, and that's why the review is taking place. Quite frankly, it is entirely clear there is no need to consent and build more wind farms in Scotland. We have met Scottish consumers' demand. We have exceeded the transmission capacity southwards. All new wind farm proposals in Scotland do is to result in increased costs to consumers and to increase emissions for no net energy gain. The clear message from the Secretary of State and the UK Government energy policy is that no more wind energy is required in Scotland. That is because it is already creating problems for the GB electricity system. The geography means that transmitting electricity from Scotland requires far more transmission lines than it does, for example, than bringing it in from the southern North Sea, from the Irish Sea, or from the Celtic Sea off the southwest of England. There is plenty of wind energy there, more than enough to meet the GB whole system energy demand. They simply do not need more energy from Scotland and the unnecessary cost of new transmission lines from Scotland to England. The likelihood is that the review of electricity markets will fundamentally change the market to provide a clear, quote, locational pricing signals, close quotes, to investors. That means locating electricity production close to demand centres, not hundreds of miles away from the main population centres. Now let me briefly turn to the Scottish policy and to the onshore policy refresh in particular. I've dealt with that extensively in my statement. I'll come on to the Scottish policy a bit more details later on. With respect to Mr. Bell's onshore policy statements, refresh comments, I don't believe that the onshore policy refresh statement gives the substantial growing onshore wind the green light that Mr. Bell believes it does. In fact, quite the opposite. For the first time, there is a quantification of the potential capacity. So we are moving from what we've had previously as being an unlimited, unconstrained capacity to now being a quantified requirement. That requirement can be met from the existing pipeline of existing consents, from repowering, and from wind farm extensions. I've set out the details in my policy in my hearing statement. Happy to pick up on more details on that. It should also be said that the 8 to 12 gigawatt ambition was raised before the latest ScotWind offshore leasing round auction results. That has delivered a committed offshore wind capacity of 25 gigawatts rather than the hoped-for 10 gigawatt target. It will be interesting to see whether, in the light of the huge volume of offshore wind which is now committed, the Scottish Government revises downwards substantially its onshore wind ambition. Of course, offshore wind has a far higher capacity. It has a higher load capacity. In other words, it can produce energy at a load factor or a capacity factor of 60%, rather than the 45% claimed by the applicant for this proposal, but more likely being realistic about the numbers rather than the numbers that they suggest. Realistically, onshore wind is delivering a load capacity of something of the order of 30 to 40% capacity load factor. So in other words, it's more efficient. So in many ways, it's now clear that the 8 to 12 gigawatt ambition is actually not required. So let me come to my overall remarks on UK and Scottish energy policy. There's an important point overall here, and that is that Mr. Bell, throughout all of his statements and his submissions, is conflating and confusing two distinct issues. He's conflating, firstly, the considerable challenge of meeting the target and getting to net zero, with, secondly, the need to get there. Mr. Bell is suggesting that by consenting and building this proposal, and presumably other wind farms, that this will solve or go towards solving the considerable challenge of meeting the net zero targets and having a net zero energy system. That is not the case. Mr. Bell has correctly identified the requirement of the challenge of getting to net zero, but the solution he gives is to consent this proposal and build more wind farms. But that doesn't work. It doesn't solve the challenge of getting to net zero. Mr. Bell's solution of more wind farms does not get us to the answer of the challenge of getting to net zero. That is because the problems of the challenge of getting to net zero is not a shortage of low-carbon electricity in Scotland, absolutely not. My statement gives much more comprehensive details on that, but it's absolutely clear we have plenty of low-carbon electricity in Scotland. With the exception of Peterhead, at the moment, all electricity generation in Scotland is low-carbon. The problem, however, is the rate at which we are switching away from using fossil fuels, particularly for heat and transport. What is needed for this transition away from fossil fuels for energy in heat and transport to low carbon energy use, it is the use of the energy that is crucial to the challenge, and the way we adapt to that is important. Not necessarily more wind energy. We already have enough low carbon energy in Scotland to meet the current electricity demands. In terms of meeting future Scottish electricity demands, when heat and transport are converted to low carbon energy, the onshore wind energy current pipeline, the repowering and the wind farm extensions, together with a huge amount of offshore wind energy, shows that Scotland has far more power than it needs to meet the full demand. Again, that is set out in my statement in detail. The only problem with this is that when the wind isn't blowing, when we fire at Peterhead and import electricity from England and Wales, but just another wind farm, just like this proposal, is not going to help. When the wind is not blowing, this proposal, if consent and built, will be just as effective as every other wind farm. In other words, it wouldn't produce anything. The proposal doesn't add any value or anything to the current fleet. At 2.5.11 of Mr. Bell's statement, he says, it is the cumulative effects of a large number of individual projects which will move Scotland towards where it needs to be. That may be so. But this proposal is not one of those projects, since it will not make a useful contribution to moving Scotland forward to where it needs to be. The projects that are needed to move Scotland forward are the conversion of energy in the use of heating and transportation, not more wind farms. That is because we have plenty of supply of wind energy. In many ways, consenting this proposal is a distraction from the really important issues. If, as Mr. Bell suggests, the focus of consenting wind farms is the answer, then we are deluding ourselves. We are taking measures to address climate change which will not be effective. We have to focus on other things. Regarding 2.2, Mr. Bell is suggesting relatively more weight should be given. He cites the Strathy decision and that it's saying that. If you read it closely, it does not. Strathy is simply stating the obvious, that the current policy documents are now quite old and that new policy is being introduced. There is indeed an increasing importance given to climate change, but the terms of the policy have not actually changed. Mr. Bell is suggesting that the new policy heightens the requirement or increases the weight to be given to new wind farm proposals. That is not the case. These are policy adjustments, not new policy. In the draft Scottish policy and the UK policy, if the draft Scottish policy and UK policy wanted to quote, give more weight, they would clearly state that, but they do not. It is possible that Mr. Bell is pointing towards and caught up in the political rhetoric, the political spin around government announcements. Perhaps he's alluding to the Scottish Government's announcement of its new coalition a while back. But that is not where policy is made. To make policy, governments have to take the political rhetoric, develop that into considered and fully evaluated policies, and then put this into the consultations and assess the public and stakeholder responses. Only at that point, and after a full process, is policy made. It is published in written form for all to see and to work to. With all due respect to Mr. Bell, the balance of policy has not changed. There is no suggestion that, quote, a relatively more weight should be given to the factors that Mr. Bell has selected that suit his client. Climate change is an important consideration in policy, but at no point in any policy is there any suggestion that the harm recognised by the client for this proposal should be simply set aside and ignored. Because of Mr. Bell's perceptions that some more weight needs to be given to the climate change and other factors, that is not the case. The fundamentals are that the planning balance and the weighing of the benefits and the adverse effects of this proposal have to be weighed as much as any other proposal. The idea that some policy priority gives more weight only exists in Mr. Bell's interpretation and in shaping his policy, not in the policy itself. I'll now come on to 2.3 in your agenda, madam, which really raises my statements, and I'll just run through this fairly quickly. In terms of oversupply, we obviously have exceeded the current demand for energy in Scotland, and the excess is more than we can ship south. We've already made that point. Even taking account of the future Scottish whole energy system demand for heat and transport, Scotland already has sufficient capacity to meet that need. Through the existing pipeline and the onshore wind consents and the huge programme for offshore wind programmes, there is a huge amount of capacity there, so that there is no need for more consents. The consequence of the current situation is that the energy cannot be used. The result is we are curtailing about 15% on a typical year these days of onshore wind energy output. The problem will get worse if consents are given and wind farms are built anymore. This is clearly an unequivocal message to the decision maker. Even the current wind energy capacity is being wasted. Details of the costs of this are shown in production 38. The electricity systems operator predictions are that this cost will rise further substantially. These are, quite frankly, not sustainable. Even before the current energy price shock took place, they were not sustainable. The problem with Scottish onshore wind is that the barriers to deployment are both substantial and real. They are not matters, however much the applicant or even the Scottish ministers wish. They can simply be ignored and that they'll simply go away. There's no sign that these barriers on the energy market regulation, on transmission charges and transmission capacity will be overcome, assuming that the applicant is able to convince the MOD of the array problem. With the current energy programme, there will never be enough transmission capacity to move energy between Scotland and England. Under the Electricity Act, the Minister has a duty to create a market. He has fulfilled that duty, well and truly. The market is now more than saturated. We currently have an energy crisis due to the post-COVID recovery and the Ukraine war. That means, particularly at this time, we need to focus on investment on low-carbon energy production, which is flexible and effective at bringing down greenhouse gas emissions. This proposal does neither of these things. Because of its location, it will not increase the production of energy because the energy cannot be used. And since the construction would result in emissions, this proposal will actually result in increased rather than reduced carbon emissions. But worst of all, at a time of a cost of living crisis driven by rising energy costs, this proposal will result in increased energy costs to consumers across the UK. The curtailment costs that will arise if this proposal was consented and built would fall entirely on consumers. They pay for the curtailment of wind energy in Scotland and will be paying more if this proposal goes ahead. We often say we need, the old phrase, the right development in the right place. The right development the right place for this development is not here. It's at least 250 miles southwards of here. There, the energy from the wind farm could be used effectively. But this proposal in this location will simply increase carbon emissions and, more importantly, increase costs for consumers. That is exactly the opposite of what is needed at this time of the energy price shock. Thank you, Mon.
Thank you, Mr. Ford. Obviously, there's quite a lot in there, and it's helpful you've gone through the points raised in the agenda. I could ask the councillors to come in just now, but I think it might be quite good if I go back to the applicant first, and if you want to add anything to what Mr. Ford has said, I can bring that in. Unless Mr. Armstrong, do you have something you want to say?
Well, it was just in relation to discussing the Strathy Wood decision, whether you want to deal with that in this response or whether we come back on that. Obviously, this witness did say something about that. Whether you want I don't mind whether we want Mr. Bell to come back, and then we can discuss that perhaps at the next stage. I see Mr. Bell's nodding that that's probably the best way forward. So I'm happy to leave it at that.
Yes, I'll allow you to come back on that once I've heard from Mr. Bell. Mr. Bell.
Thank you. There is quite a lot there. I'll try and take it reasonably quickly. But overall, I think the narrative that we have heard this morning, the applicant largely rejects that as a flawed approach, which would largely be contrary to the Scottish Government's policy position. Just taking the points in order, in terms of the sixth carbon budget, the 25 to 30 gigawatts of onshore wind for the UK is in all the scenarios. That's page 163 of CD 11.020. It is an advisory document. It's the government's independent advisor on climate change. So Mr Ford is correct in that it is not in itself policy, but it has informed policy documents such as the White Paper and other documents that have followed the carbon budget. The suggestion that there should be a geographical apportionment of the 30 gigawatts has no policy or guidance basis at all. In terms of the UK Energy White Paper, onshore wind is referred to as a key building block. I think it's notable that Mr Ford refused to use that word, and he did not quote it, the word key, in his evidence. He missed that out. I think the word key building block is so obvious, it's a given, that solar and onshore wind, easily deployable, low-cost technology, the UK government recognises what they offer. In terms of the EN series of national policy documents, these do not apply in this inquiry. I can't recall any inquiry or appeal in Scotland when they have been deemed to be competent documents to place weight on in a determination. There is very little, if any, reference to onshore wind in those documents. We know it's referred to in the Planning Practice Guide in England and the NPPF, but the policy approach is highly restrictive. Mr Ford suggests there's no answer to why this is. Well, it's very obvious that over the last few years and since 2015, the Conservative government has been strongly opposed to onshore wind, and that has been reflected in English national planning policy, where effectively policy was written such that it switched off the market. I don't think there's any dispute over the facts of that. In terms of the next document Mr Ford referred to, which was the British Energy Security Strategy, which is CD 11.036, that talks about, and I should say I've referred to that in my hearing statement, pages 18 and 19. It talks about accelerating the transition away from fossil fuels, growing the proportion of electricity from renewables. And in terms of onshore wind, it's evident that the UK government's recognising that Scotland has its own planning system. It states on page 18, Scotland has its own planning system, and it refers to the position in Wales. So there's a clear distinction between the very restrictive planning regulations for onshore wind in England and the untrammelled approach of the Scottish Government to deliver their own energy policy, despite it being a reserved matter to Westminster. So whilst that document does talk about new nuclear, we know that will not appear in Scotland from the government's programme for government. Offshore, of course, is supported, and that needs strong government support, and that will deliver a big chunk of energy that is required. But we know from the earlier references I made to the onshore wind documents that that has an important and vital role. In terms of the speech from the Bayes Minister, Kwasi Kwarteng, that was referred to, I don't have it before me, but I read it, and clearly concerned about energy security in light of the geopolitical events going on, and that also comes through in the energy security strategy that I've just referred to. and that talks about accelerating the transition. So we cannot wait, I would say, until new nuclear may come on stream. We know offshore wind takes a long time to consent, whereas onshore wind is the technology that the Scottish Government recognises will have, in particular, an important role through the 2020s, and that's made clear in NPF 4 in the preamble to Policy 19. So the next point Mr Ford referenced was that onshore wind in England is not a priority for the Scottish Government. I think that's a fair point. We know from the National Planning Policy position why that is. But that's not the case in Scotland. In terms of the various references to curtailment and oversupply, we don't agree with an oversupply position, but insofar as there may be wider GB network issues with the grid, that is, we say, not for this inquiry. And SPP paragraph 165 makes that very clear. In terms of Mr Ford's position that there should not be any more onshore wind consents in Scotland, perhaps he's suggesting that only has to be repowering and wind farm extensions. That is simply not the Scottish Government's position. There is no policy or guidance restricting onshore wind to those categories. And any suggestion that onshore wind extensions are easy to consent is simply not borne out by the evidence. There's a database that shows numerous extension refusals in Scotland. In terms of repowering, there's actually, whilst that's a positive thing to happen, there's very little activity. Hagshaw Hill has been repowered, but I don't think there's any other applications in the planning system. Very few. In terms of the load factor, or capacity factor that was referenced, the 45% that is referenced in the application document is based on MetMass data and industry standard wind modelling software. Now, the technical details of that can be provided if required, but the applicant's other developments, Aiken-Gall, achieves around 47%. Sanker 1 in Dumfries and Galloway is about 50%. So the 45% for this scheme is backed up by real-world observations of operational schemes, and that further demonstrates why this is a good site. The average load factor that was referenced by Mr Ford is largely driven by a large proportion of lowland sites and largely old technology. In terms of the suggestion that this development would not make a useful contribution and, in fact, would increase carbon emissions and not produce any energy is simply not accepted. And that, we say, is an extreme position which should not be afforded weight. Mr Ford then suggested that if the government wanted any increased weight to be given to matters, that would be expressly set out in policy. Now, it's not for planners to look for, or decision makers to look for exact guidance on weight in policy documents. That is for the decision maker when looking at any relevant material considerations. Coming to the end, I think in terms of network costs, whilst that may be an issue, in terms of curtailment, there is also wider issues of other energy generation having to run as part of baseload, and that is not unique to as an issue to wind energy. But our view is this inquiry should not be delving into those matters. Again, paragraph 165 makes it clear that those are not to be considered for individual applications. That, ma'am, is a rebuttal of the points made by Mr Ford, there were one or two additional points that I was going to make that were in response to item 3 on the agenda, which I'm happy to run through reasonably quickly, just to finish off that topic. In terms of the contention that beyond repowering and extensions, that the current consented but yet unbuilt pipeline can be fully relied on is not accepted. The government has consistently made it clear that targets do not relate to consents but relate to actual installed capacity, and that it's evident that there's a number of consents sitting there that will not proceed to implementation. Now, one of the factors has been the speed of technological change to deliver greater yield turbines, and also the vast majority of developments that are up and running in Scotland have enjoyed price support by way of the renewables obligation or the more recent contracts for difference. That is why the planning system is seeing many tip height extensions, and I'm sure Mr McTeer and Mr Shearer might give us numerous examples of what's on their desk at the present time or in scoping. Just some examples: Hops Rig, Little Hart Fell, Logan Head, Mockram Fell, Strathy South, Limekiln, Polquhairn, Stranach, Cloich. They are all schemes that were consented but have not proceeded. They're back in the planning system to achieve higher tip heights, and not all of them will succeed. Now, the Scottish Government, in the existing onshore wind policy statement, paragraph 9, states that, this is a quote, "The arrangements which have enabled onshore wind to expand and to reduce its cost so successfully are no longer in place. Continued innovation and cost reduction, a supportive and well-resourced planning system, and continued advances in turbine and blade technology will help close the gap that currently exists, but not sufficiently and not for all developments." So that's recognising that technological advancement will help some of those schemes in light of the lack of price support. So I think I'll call a halt there, and that is the conclusion of the response. There's a lot more detail behind that, but happy to go over to other parties. Thank you.
Okay, I'm going to ask Dumfries and Galloway Council to come in with any comments on what's been said so far.
Yeah, Mr McTeer will go into the general detail, but just on one point, that the Strathy Wood Wind Farm report, where Mr Bell refers to it at paragraph 22 of his statement, and Mr Ford referred to that today. Mr Bell quotes from paragraph 11.93 of that report, which is CD 1531. That quote has obviously got to be seen in context, and seen in the context of the findings of the reporters and conclusions in that report, and in particular their findings in relation to the development plan at paragraph 11.67, and also the fact that that conclusion is essentially addressing an issue advanced by a third party at that inquiry, the Wildland Limited case. And that can be seen from paragraphs 1150 and 1151 of the conclusions of the reporter on policy context. And what Mr Bell misses out is the conclusion at paragraph 1151, where the reporters conclude, however, we do not consider they have been elevated to reduce the importance that should be given in the overall balance to adverse environmental effects. And again, it's specifically that one in relation to the context of considering the matter of need. And that conclusion of the reporters, in that case, is of course consistent with the Scottish Minister's findings in a number of other cases that Mr McTeer refers to, and in particular in relation to the Galty Clay wind farm, the Crystal Rig 4 wind farm, and of course the North Lowther wind farm reports, which are 1528, 1545 and 1547, and in particular in relation to the North Lowther one, the conclusions at paragraphs 270 to 271, which were adopted by the Scottish ministers. My point, from a sort of legal viewpoint, is that obviously paragraph 2.5.12 of Mr. Bell's conclusion, Mr. Bell's statement on page 22 and his selective quote has to be seen in context. I would also add that he has missed out the first sentence in paragraph 1193, which helpfully puts the quote that he's using in context. With that introduction, I'll pass over to Mr. McTeer.
Thank you very much. Helpfully, ma'am, your agenda, as set out, is looking to go over areas where the parties kind of differ in their views. But I will begin with 2.1 with a point of agreement in that Mr. Bell does refer to these documents, CD 11, 20 and 21, which highlights support for substantially growing onshore wind to attain the targets set out within them. There's no dispute from our point of view that onshore wind will assist with these targets. That's probably where the agreement ends. These policy documents make no change to the balance between target reduction and environmental factors, and I think it was Mr. Ford mentioned in his statement that development needs to be in the right place. Now that's not going to be the first time that's mentioned, and it's certainly something that is a thread that runs through our evidence in our hearing statement that we've submitted ahead of the inquiry. Turning to 2.2, the Strathy Wood decision, which is referred to there. The reporter states that Scotland's wind energy, climate change, energy policies and planning policies are all material considerations when weighing up the proposed development. That's page 19 of the Strathy Wood decision notice, which is core document CD 15.032. It's clear to us, certainly, that energy and land use policy are one, they're not separate entities. So land use is distilled from national policy. From Dumfries and Galloway's point of view, LDP2 contains the same national policy distillation. The same decision notice goes on to state that the Scottish Government's energy strategy and the onshore wind policy statement all reaffirm the vital role for onshore wind in meeting the country's energy targets. The statement sets out the Scottish Government's position for the ongoing need for onshore wind, but the key is where it can be accommodated, and that is the key sort of issue for us for here. It's also worth noting that the reporters for Paul's Hill 2 and Millenderdale, core documents CD 1522 and 1523, concluded that added weight to one element of the balance does not in itself make a proposal acceptable overall. Turning back to Strathy, again, paragraphs 1142 and 1193 refer to the danger of double counting if the need case is given weight when support for renewable energy development is already integrated into national land use policy and the local development plan itself. The reporter states, and I'll quote, "In any event, the need case, as expressed through the the extensive references summarised in the application documents is not a material consideration. To be consistent, need should not feature as a reason for consenting a scheme. Moving on to 2.3 in the agenda, where Mr Ford is looking at the onshore wind policy statement refresh. We've covered that in our hearing statement quite comprehensively, paragraphs 4.15.1 to 4.15.8, and the only sort of additional thing that I would add to that is in relation to the barriers of deployment round about the Esdale-Muir array, and from our own sort of point of view in terms of developing applications, determining them, it's good to see that there's positive moves with regards to the Esdale-Muir array. That's really all I've got to say just now in terms of the first 3 points on the agenda.
Thank you, Mr McTeer. For Scottish Borders Council?
Thank you. Unsurprisingly, we have a very similar position to our colleagues over in Dumfries. I would also start by saying that there's agreement that it's clear that energy policy will continue to promote the use of onshore wind to help meet renewable targets. However, the planning system still requires a balanced approach to be taken when assessing the suitability of proposals in the round, where the environmental benefits and disbenefits are still required to be considered on a case-by-case basis. This approach was advocated by the reporter in the determination of the Gilston Wind Farm, core document 1558. At paragraph 121, it was found that energy policy provision should not take precedent over the need for a balanced assessment to reach suitable planning decisions. I feel that this decision aligns with the onshore wind policy refresh in the ministerial forward towards the end of that, where it was there was an overview at the end that any capacity which is developed needs to be fully aligned with and continue to protect natural heritage and native flora and fauna. So yeah, it's very much that issue of still striking the balance of the correct development in the correct location and the need to consider all relevant considerations in the round. Thank you.
Thank you, Mr Shearer.
Thank you very much. I have nothing further.
Okay, unless there's something further on these particular issues under point 2 of the agenda, I've heard quite a lot of information on all sides. Is there anything further from the applicant before we just finish up for lunch and take on the next items after that?
Just a few brief points. Thank you. I think in terms of the energy and land use policy being one, I think Mr McTeer put it that way, I think there is an important distinction between the land use planning policy and the interaction with law and targets, in particular the 2019 Act. That's clearly changing, and we'll come on to that probably in the next item on the agenda. I think there is consensus with both planning authorities about development where it can be accommodated. I think that's not in dispute. In terms of the planning balance, of course, that has to be applied. Again, that is not disputed, benefits against disbenefits. But in terms of this notion of double counting, I think it's clearly you've got SPP and NPF3, But since 2014, when you bring in the new law by way of the 2019 Act, the climate emergency, the onshore wind policy statements, and so on, and the fact that targets are not being attained, these are material matters. And essentially what I'm saying, I think probably the best reference in my hearing statement would be 7.5.7. So it's not that there's a watering down of environmental protection. You know, it's accepted that remains the same. But what I would say is that it's open for a decision maker in any planning balance, whether it's for a housing project or an industrial project, to place more weight on the benefits if policy is suggesting through its clear reading that that is the thing to do. So that is where the applicant's coming from. I think lastly, in terms of Strathy Wood, the full quote at 11.93, the first sentence about the Wildland Limited's concerns about double counting. I was at that inquiry, and it was a consistent point that's raised by Wildland, which is along the lines of, if you're giving weight to SPP, you cannot give weight to other energy policy matters. So all the reporter is doing there is saying that she is mindful of the Wildland position, but goes on to say, at the same time, and we recognise, and the rest of the code comes in. I think, very finally, it's interesting to note that both councils are not repeating the extreme position taken by Mr Ford, and therefore I'm assuming that they don't agree with the position he sets out for no additional onshore wind development should be consented in Scotland. Thank you.
Just on that final point, is there anything that either of the councils want to add, or am I right in understanding that you are in general agreement with the applicant on that?
Ma'am, the need and importance to reducing emissions is not disputed, and the important role that appropriately cited wind energy development has in contributing to reducing emissions is accepted and is obviously reflected in the Council's local development plan policies. It is, as Mr McTeer set out, it's the assertion by the applicant that the need case should be given greater weight, and by implication that sites that are inappropriate in terms of their location, siting and design should now be consented, where in the past they should have been refused, that the Council does not accept. And the Council also does not accept that there is any conflict between UK and Scottish energy policy and land use policy, and the Council does not accept that by implication Scottish Government policy has changed. It has not changed, and the Scottish Government would not change their policy by implication. Clearly, there's matters like the strategic environmental assessments, clearly matters in relation to consultation would have to take place first before there is any shift in policy.
Anything further from Scottish Borders?
I don't think we would be in a position where we could say that we have a view that there should be no more wind farms in Scotland. I think it comes back to the point that every application has to be considered on its own merits, and the benefits and the disbenefits considered in the round.
Okay, thank you. Mr Ford, do you want to make a final point?
Yes, ma'am, thank you. The point is not that there should be no more wind farms in Scotland, and Mr Bell is misrepresenting my position with all due respect to him. I accept that there will be more wind farms in Scotland, and in terms of the 8 to 12 gigawatts of capacity, what I'm saying is that there is provision for that already. Mr Bell talked about the pipeline and that some developments will fall out of the pipeline. I quite accept that. But no doubt they'll be replaced. But the repowering is quite substantial in terms of its capability. The extensions, I accept with Mr. Bell's point that the extensions are quite modest, and actually, if you look at the numbers in my statement, Ma'am, that is the appropriate balance I give them. I am not suggesting there will be no more wind farms in Scotland. The proposal, the point I'm putting across is that the expected ambition, assuming it stays, can be met. That my point is twofold here, 2 points here. One is that this proposal isn't needed to meet that ambition. That's the first point. And the second point is that there is a general problem with oversupply of energy in Scotland, and the minister should recognise that and should take that into account. This problem will apply to offshore wind as much as to onshore wind, but Ms. Bell is misrepresenting my position with all. And thank you for the opportunity to come back on that, Ma'am.
I was just going to come back. Yeah, so if you just want to come back on that final point.
It was just, I'm grateful for Mr. Ford for clarifying his position. I wonder if his paragraph 1.8.1 of his hearing statement can be struck out in that case, because he states very clearly there that the target, as he puts it, can be met without developing wind farms on new virgin sites. Consequently, under Scottish Government policies, there is no need for consents to be awarded at proposed new developments on virgin sites, such as this application. So that would seem, his position just verbally here would seem to contradict that.
Sorry, did you say 1.8.1 of his statement?
I believe so, yes. The paragraphing in Mr. Ford's hearing statement is all awry, I have to say. There's numerous similar paragraph numbers, which is a problem.
Mr. Ford, could you clarify where that statement is made?
Well, I'm looking at 1.8.1. But Mr. Bell, no, I'm not prepared to withdraw it. With all due respect, what I'm simply saying is that in terms of that 8 to 12 ambition, we have the pipeline and the potential to cover that requirement through repowering without going onto virgin sites, such as this proposal.
Ma'am, could I just clarify one point? My 1.8.1 doesn't seem to, of Mr. Ford's statement, doesn't say what.
No, mine neither. Mr. Bell, could you clarify for us, please?
I have to say the numbering seems fine on the version that I have, which is a PDF, not a Word document.
Sorry, you just bear with me. Yes, it's paragraph 1.8.8.
That's correct, yeah. It refers to new virgin sites.
It's perhaps a later stage in the document where the numbering goes awry.
It's that paragraph 1.8.8.
Yep.
That's the quote.
So it's underlined and it's in bold, without developing wind farms on new sites.
Virgin sites.
Okay, I take the point that's made. Thank you. I think now is probably a good time to stop for lunch. And if we can just be back just before 2 o'clock, is an hour too long enough, or do we need a decent break, or 45 minutes maybe do enough for everybody? Depends if you've got lunch or need to go out anywhere.
Yes, I think if we just the hour, simply because the hotel can't provide catering, so we're going into town.
An hour then, so back at 2 p.m. Thank you.
Ma'am, can I just clarify one point? If we're leaving computers here, will this room be locked? Or?
Graham, can you clarify? It won't be locked, so take any personal possessions with you, but if you can just shut down your laptops. I mean, I'll be around, so I can obviously make sure nothing's removed from the room. Okay, thank you. See you at 2 p.m. Okay, welcome back everyone, and we'll move on in the agenda to item 3, which is where I want to explore with the parties the National Planning Framework, kind of planning position that sits at national level, and Scottish planning policy, which dates to 2014. Now, again, I'll just run through a couple of things that have been said by two of the parties, the applicant and Forsyth Community Group, but also I'll bring in the two councils, Dumfries and Scottish Borders as well, to comment on these matters. So, firstly, Mr Bell considers that national planning policy, including National Planning Framework 3 and Scottish Planning Policy, has been largely overtaken by new statutory provisions and related policy on renewable energy and greenhouse gas reductions. The national outcomes and draft NPF 4 is cited as signalling a key change to the spatial framework, and he suggests it will not be business as usual in decision making, with climate change to be one of the guiding principles. And the proposed development also, this proposed development would attach national development status in the draft National Planning Framework. Mr Ford also makes some comments on the draft National Planning Framework 4. He argues that the essential criteria for decision-making on onshore wind farms, such as the consideration of local environmental effects and accessibility of potential impacts, the balance against perceived need, will remain fundamentally unchanged. So, similar to this morning, we have parties giving quite opposed views on these matters, and I'll explore that with the councils as well individually once I've heard from the applicant first and then Mr Ford. Mr Bell.
Thank you. I think the summary in 3.1 is fine. The only point I would make is that I wouldn't say there's a key change to the spatial framework from the outcomes, but the rest is fine. The point I make is that in terms of NPF 3 and SPP, the reference is to a shift to a low carbon position, but now that has changed to net zero. That is a fundamental difference. Also, I think it's sometimes overlooked, but in SPP, Scottish Planning Policy, paragraph 154, which lists the targets as they were back in 2014, there is a footnote on the word targets. And that is often overlooked, but the footnote says further targets may be set in due course. For example, district heating targets have been proposed. So I think the government was mindful that the targets would evolve. District heating was clearly on the horizon in June 2014 when that was finalised. But there has been clearly a fundamental shift with the 2019 Act, amending the Climate Change Act, and the statutory targets for each year. And I've set out in my hearing statement what these are and the performance against them so far and the shortfall. So that's the interaction between policy and targets that we touched on this morning. In terms of NPF 4, I deal with that in my hearing statement at 3.4 in some detail. I highlight the outcome statements, which are in Annex 5 of NPF 4, and outcome E is meeting any targets relating to reduction of emissions. And the point I make is that the outcomes are not being consulted on, neither is net zero, that's set in law, and these are key elements of NPF 4. And I also referenced that in terms of the role of onshore wind, NPF 4 in the preamble to Policy 19 talks about, in particular, the role of onshore wind in the coming years as being important. So overall, I would say that the planning policy framework has not changed. That remains the spatial framework approach. and paragraph 169, but the statutory footing, the targets and that net zero context has changed already, and that can be afforded significant weight. The final point I would make about the targets is the benefits of early consent. So the earlier the delivery can be made, then that gives a disproportionately higher benefit compared to consents coming in 2040. I think an analogy could be drawn perhaps with an ISA account. You know, the sooner you put your money into that year, the greater the benefit than leaving it right to the last minute of that financial year. So I think that is really a summary of, a very quick summary of, I'm conscious we'll get into the special framework in later questions, but that is, if you like, the change between the SPP 2014 position and where we are now. We clearly need to apply NPF 4 and NPF 3, but the statutory context and target position has changed.
Thank you, Mr. Bell. Mr. Ford.
Thank you, Mom. Mr. Bell is again trying to suggest that the balance of policy has shifted and is shifting towards the wind farm development and that it won't be business as usual. He says that climate change is the guiding principle. Mr. Bell is saying that the need for this proposal is driven by the policy, and that the policy is saying that we need more electricity from onshore wind, you know, that's needed essentially to mitigate climate change, and as quickly as possible. He claims all policy points in one direction, which is to approve the proposal, and presumably other wind farm proposals as well. He claims the cost of the harm done by the building wind farms is outweighed by the benefit of meeting climate change. But the production of energy is not justified by the policy. The production of electricity is not justified by the policy. The justification for the policy set out in the draft NPF 4 and in the outcome statement is, quote, meeting any targets relating to the reduction of emissions from greenhouse gases, close quotes, which is within the Carbon Act for Scotland. The objective of coming policy, set out in draft NPF 4, is to achieve carbon savings in the course of electricity generation and weighing the climate emergency when making decisions. So to achieve carbon savings in the course of electricity generation and weighing the climate emergency when making decisions. So the policy is not to deliver this proposal and as many wind farms as possible. The policy objective is to decarbonise electricity production, the energy system and the whole way we live. Wind farms are not a policy objective in their own right. That's worth restating. Building wind farms is not a policy objective in its own right. Importantly here, if electricity generated by a renewable means from this project cannot be delivered to the market, there cannot be any need for this project, since it is only capable, its only capability will be to generate something that nobody can use. In other words, it delivers no benefit. If the proposal delivers no benefit, is there any need for it? We suggest no, there isn't. This actually echoes Scottish Government policy, which is the old phrase referred to earlier on, the right wind farm in the right place. If the energy and electricity cannot be delivered, it cannot be the right place. It's a simple proposition, simple conclusion. Applying that logic, the application must therefore be refused. Just another quick point here, and that Mr Bell refers to the national outcomes, which arise under the Community Empowerment Act for Scotland 2015. These outcomes include that communities are empowered. It is deeply ironic that in Scotland, decisions on wind farms are taken by Scottish ministers and not by local planning authorities, as in England and Wales. In England and Wales, the local communities are empowered to be the primary consideration of whether or not the wind farm should go ahead, and also what the community benefits and sharing will be. The community here rejects this proposal, and in deciding this proposal, I trust that the decision makers will indeed, to use the terms of the Community Empowerment Act, empower the local community and abide by their choice to reject this proposal. Thank you, Mark.
Thank you, Mr Ford. Can I just ask the councils now to come in on their understanding of the weight to afford to MPF4, their understanding of its content? I know that Dumfries and Galloway says that a very extreme, I think I'm quoting, extremely limited, if any, at present weight should be attached to MPF4. I don't see similar statements in Scottish Borders' statement, so I want to maybe ask you first what your understanding and take is on this matter.
Thank you. We wouldn't dispute the direction of travel for MPF4 is to increase the delivery of renewable capacity, but MPF4 is still yet to be finalised and it could still be subject to change. Opinions that we should be seeking to preempt what MPF4 will look like are understandable in the current climate, but if we do that, we are at risk of with making decisions that turn out not to be aligned with the final MPF4. We believe that we're still in the era of MPF3 and SPP. We acknowledge momentum is clearly building in energy and planning policies for hitting the net zero emission targets going forward. But it is worth noting that draft MPF4 doesn't suggest or indicate that site-specific considerations should now be set aside or given any less weight than before. Certainly more weight is to be given to meeting the net zero emission targets for the MPF4, but that is not at the expense of a need for renewable energy developments to account for the site-specific considerations which are listed under the proposed policy 19 green energy.
Mr Armstrong.
Mr McTeer will deal with that point. I have two sort of just legal points in relation to Mr Bell's statement on this. I don't know if you want to hear them now or whether you want to specifically, well, if I deal with them just now. The first is in relation to page 13 of Mr Bell's statement in paragraph 2.2.10. That's correct on page 13, ma'am. And Mr Bell quotes part of, should I say, section 3 ZA of the 1997 Act as amended by the Planning Scotland Act 2019. He does omit, though, subsection 3 of, he quotes from subsection 1 and 2, but of course subsection 3 sets out, as can be seen from document CD 16.2, which has the relevant section in it in the first page, that this section applies only to the Scottish ministers and planning authorities' exercise of functions under Part 1A and 2, and that's in relation to national planning frameworks and local development plans. It's not obviously in relation to considering consents either under the Planning Act or under the Electricity Act, and it's important, ma'am, that regard is had to that subsection 3, and I'd submit with respect to Mr Bell, he's taking that section out of context there. And the second point is on page 30 of Mr Bell's statement, and the section beginning paragraph 3.4 23 onwards. and the conclusion at 3.4 at 27 that these statutory outcomes are not being consulted on and are set in law. Well, Mum, again, that's got to be seen in the context of the Act and what it actually sets out. It sets out that the law provides for the Scottish ministers making a statement on how the development in the MPF will contribute to the outcomes. It's not requiring that any proposals are assessed against the outcomes. And again, with respect to Mr. Bell, he's taking that section of the Act completely out of context. With that introduction, I'll pass over to Mr. McTeer.
I'm not intending to dwell for very long on NPF 4. The Council's position set out in the hearing statement that we submitted for this, and ma'am, you very helpfully summarised what our position is with that, and my colleague from Scottish Borders Council alluded to as well. NPF 4 is currently a consultative draft, which is potentially subject to change following the consultation period. So we feel that it is entitled to limited weight at present. We can see the direction of travel that planning is taking, and that's welcomed certainly across the planning authorities. I'm pretty sure. But until such time as NPF 4 is adopted, and there's uncertainty as to when exactly that will be, NPF 3 and Scottish planning policy are the national policy documents from which decision making is derived. Thank you.
Thank you, Mr. Victor. Mr. Ford, I wanted to ask the applicant to come back, and then I'll see if is there something further you want to say on that particular issue?
No, Ma'am, it's just I'm very sorry, but I've just been looking at my notes. I realise I've actually not covered 3.2 on your agenda, so perhaps I could just briefly cover that.
Yes, you can.
Thank you. Obviously, the criteria set out in SPP 169 is being carried through into the draft MPF policy 19K. Those criteria are essentially the same. So the policy criteria for judging the proposal is essentially unchanged. So we're back to the right development in the right place kind of scenario. But what has changed since SPP was issued in 2014 is our energy circumstances have changed fundamentally. Back in 2014, we had coal-fired power stations in Scotland. We had a large dependency on fossil fuel in Scotland. There was relatively little renewable energy, apart from some historic hydropower in the north of Scotland. There was therefore a pressing need to build low-carbon electricity generation, and essentially SPP was addressing that. As I've shown in my statement, Table 3, and the onshore policy refresh confirms, Scotland now has a substantial capacity for renewable energy. We have 10.3 gigawatts currently of wind energy, 2.4 gigawatts under construction. That's 12.4 gigawatts of wind energy imminently. With the old hydro capacity, that is 14.3 gigawatts of low-carbon energy in Scotland. And obviously that's setting aside the nuclear plants in Scotland, which are expected to finally close by 2028. But as set out in Table 2 of my statement, we know what the future Scottish whole energy system requirement is. Table 4 of my statement demonstrates that we have sufficient capacity, either in the construction pipeline or committed, particularly of offshore wind energy, to meet our need. As a consequence of these, we do not now need any more onshore wind proposals to be consented. There is therefore no need to incur the harm to the environment, which I know the the applicant accepts, that would arise if this proposal was built. Furthermore, the onshore wind policy sets out comprehensively that there are substantial barriers to deployment. this means that the energy proposed cannot be used. Thank you, Mon. Thank you for your extra opportunity.
Okay. Mr. Bell, do you want to come back on these points that have been made?
Yes, I'll do it fairly briefly. I think just taking it in reverse order to start with, that last point seems to again contradict the position Mr. Ford gave before the break. He's just said there's no need for any more onshore wind sites to be consented in Scotland. I think I've got my notes correct. Yep. We can check them afterwards, but I think that's what was said. In terms of Mr. Ford's first point he made about all policy pointing in one direction in my evidence, I don't accept that. I think it's clear in my evidence that there's a balance to be struck and that there are various environmental considerations coming into play in terms of SPP and the development plan policy as well. In terms of there not being a policy objective for wind farms in their own right, I would dispute that. I think the onshore wind policy statement is a technology-specific policy related to wind energy. In terms of the outcomes, I take Mr. Armstrong's point, and what I would say is I'm not saying that that is a determinative matter in itself to apply to the individual application. I fully accept that that is the Scottish Government and Planning Authority direction, if you like, where it's aimed at, and that indeed is what I set out at 2211. And it's in the NPF4 context where I refer to those outcomes. And in terms of the changes and weight in NPF4, I think there's agreement that it's limited weight to the draft policies. It's a conventional approach in planning. The policies may be subject to change. But there is consistency with the government's approach that beyond national parks and national scenic areas, development should be supported in principle. And that's very similar to the current spatial framework approach that we'll be coming on to. Thank you.
Okay, thank you. I'm going to move us on now. So I'm going to move us on now into look a little bit more detail into Scottish planning policy and in relation specifically to the spatial frameworks and the Table 1 in SPP. Now, I am just looking for a little bit of clarification here, probably from the two councils probably will help me best here. The extent to which parts of the site are covered by falling within Group 2 areas and in Group 3. So could I ask maybe, I'm just wondering who best to start this off, maybe Scottish Borders to explain to me. Are you just talking from your statements refer to these areas individually? So I presume you're talking from your own perspective of how it covers your council area, that it falls within a particular area rather than the other.
Yes, that's correct. Applying the criteria set out in Table 1, there's two water courses, one known as Gideon's Clook and the other as Rangeway Burn, which connect to the River Teviot, which form part of the River Tweed SSI. They run through the northern part of the site. Understand that I think they're just located within Scottish Borders geographical area and don't extend down into Dumfries. Those water courses are shown on figure 8.1.1 in core document 00271 in the EIA report, and there's also it was also identified, obviously, there were areas of carbon-rich soils, deep peat and peatland located within the site as well. Again, figure 10.5 identifies where they were. That's core document 002.98. However, we do accept that the applicant with Nature Scotland, they kind of bottomed out the impacts on peatland. Thank you.
Mr. Armstrong?
Mum, we were thinking in response to this question, that there is obviously map 8 in the local development plan, and we have managed to sort of blow that map up and to show exactly the areas that are relevant for this consideration, and that could be produced rather than just Mr. McTeer going through where the areas are. And I think that's probably the easiest way of dealing with that.
Just a suggestion. Mr. Shearer's helpfully referred to figure 10.5, which is what I was going to refer to. There's a part A and part B to 10.5, and they show in very good resolution compared to the Dumfries and Galloway Spatial Framework, the carbon and peatland soils over the site, with the layout on top of it. And that's based on the peat probing and specialist assessment. So it takes us to a much finer grain of detail of the factual position in terms of the Group 2 coverage, in terms of the classes of carbon-rich soil and peat. And related to that, there's a very helpful document which is the response from Natural Power to SNH on peat, and that is CD 05.049. And so CD 05.049, and it sets out in section 4.3 a summary of the position of all the turbines and the peat depth that they're in. So, in summary, that is, of the 45 turbines, 21 are on peat with a depth between 0.5 and 1 metre, and only 3 turbines on peat greater than 1 metre depth. And it sets out the peat management plan summary and also the mitigation actions to minimise impact on peat. So that's section 4.3 of that document. And the result is that there is no objection from SEPA or SNH, and the conclusion is reached that the effects in relation to that Group 2 resource in SPP has been satisfactorily resolved. And what I would caution you against is following any of the figures in Mr. Ford's evidence, where he refers to the number of turbines in peat. It's simply wrong, and the accurate data is in the 2 figures that have been referred to and in the submission by Natural Power.
Can you clarify for me in Mr. Ford's statement which aspects you consider to be wrong, just so I can...
I think it's paragraph 1.5, but given I got that wrong before, I'll just check it. 1.5.4.
Just give me a moment to just catch up on all that. So, Mr. Bell, are you saying Mr. Ford's statement where it refers to the development all except one of the 45 turbines on peat,
yes,
18, 40% to be sited on Class 1 peat, you're saying that's...
Yep, I think the accurate position is to go by the figures in section 4.3, and that will marry up with the mapping in the 2 figures.
So, let me just get this up in front of me. Okay, I can see paragraph 4.3 of the response from
So
Natural
that's
Power.
PMP summary, and if you go over the page, fortunately the pages aren't numbered, but if you go over the page, there's a bullet point, Scottish Government peatland survey, and then below that it says an extensive field campaign was carried out with 1,335 measurements taken. And then it goes on to give percentages, and then the last sentence talks about the turbines on peat depths.
Okay, I see where you are. Just coming back to you, Mr. Ford, just that clarification that's just been given by Mr. Bell in relation to peak depth and number of turbines, does that change your statement in any way?
No, well, perhaps I could just cover this point. What Mr. Bell says about natural power is quite interesting, but actually not relevant. If we go back to the SPP Group 2 classifications, it refers to the extent of carbon-rich soils. This arises because it refers to, and I quote, other nationally important mapped environmental interests. So by mapped, my personal view is, obviously it's down to your opinion at the end of the day, Ma'am, but my personal view is that relates to the existing data. And just to explain to you how I've got my data, I have taken the S&H mapping of the peak classifications and applied it onto the site using the turbine locations set out in the EIA. Don't remember the section number, but there's a list of specific turbine locations given grid references, and plotted the two against each other and the extent of the site using GIS systems. So in my response to the procedure notice, I set a map, which I think is figure 1 in that submission. And that's how that's been achieved. And what that shows is that 70% of the site is covered by peat or carbon-rich soil, to use the terms set out in SPP Group 2, with 15% of the site covered by Class 1 peats. So, you know, what is important in terms of the SPP here is actually the mapped data, not necessarily what Natural Power say. I appreciate Natural Power have updated their data. You'll be aware, Ma'am, that we have, and my clients generally have raised questions about that in terms of the carbon calculator, and I don't necessarily want to get into that now, but essentially we don't necessarily accept the reliability of the data. There's been no verification of the natural power data, unfortunately. We would love to see that, to be able to corroborate or verify it, but we've not been able to check that. And it's one of the reasons why we have wanted to raise the issue about the carbon calculator, and partly to cover these issues, but also to give the applicant ample opportunity to respond to them. Thank you, Ma'am.
Okay, I understand you're going into a matter that I've agreed is going to be covered by further written submission, and it highlights to me that some of this does need to be explored as part of further written submissions. So I won't get into that orally now, but I'll just let the applicant come back just on the particular point you raised.
Yeah, thank you, Rob. Just a brief point. I think it's not appropriate to apply the 2016 mapping on a determinative basis. I mean, it's very conventional for any application to be supported by site-specific information. And the Natural Power methodology, section 3.1, refers to the higher resolution 10 to 20 metre grid and the sampling of peat cores. So that's professional geotechnical engineers and hydrologists going onto the site, following the methodology agreed with SNH and SEPA, and coming up with the mapped results based on over 1,300 cores that have been drilled into the ground. So to suggest that taking the crude national level mapping and applying it is giving a more confident position than the overall sample population of that 1,300 is simply not accepted. And we have the position that the consultees are content with the approach that has been followed. Thank you.
Okay, I'm going to leave that matter there, and it is a matter that I'll explore further with the parties in further written submissions. Just coming back to Mr. Armstrong's point about what I was trying to understand was the kind of the layering of the different the groups 2 and 3. Your suggestion was to rely on figure 10.5 of CD 298, which might be a useful document as well to have a look at. But sorry, did you want to come in on something else?
No, Ma'am, it was just to offer to, from the Local Development Plan Department of the Council, they have a larger map which shows the Group 2 and Group 3 specifically in relation to the area around this site. If that would assist, Ma'am, that can be produced to the inquiry.
That could be helpful. It may be that it's something that you can submit to me, and then I can have a better understanding initially before I then put out the procedure notice for further written submissions. It will help useful background. Yes, please. Thank you. Can I just make a note of that particular document, of what you're going to produce?
Sorry, yes. It's map 8 as part of policy IN2. So it's the one that's in the LDP, shows the entire region with the different groups on it. So obviously it's a very, very large scale. And I did ask one of my colleagues in the development planning team if it would be possible to zoom in on the area to the north of Langham, round about where this is, because it is, you know, at the larger scale, it's very difficult to kind of pin it down, so to speak. So I do have this available if it helps to clarify the groups.
I think my questions really were just trying to understand that. That would be very helpful, a decent scale that we can make sense of it. If there's no objections to that, presumably, that would be fine. Okay, I'm going to move us on now onto the next point in my agenda. So Mr. Bell provides an assessment of the proposed development in Table 3.1 against the principles within paragraph 29 of SPP. Now, these are the principles that really talk about defining what is a sustainable development, and they're often used in that kind of way in planning decisions. So I'm going to ask the parties to explain, in the context of these principles and reflecting on the applicant's assessment, which you will have seen, whether the development, your view, represents sustainable development. Now, I was going to ask you to keep this reasonably brief. Obviously, there'll be a lot of evidence that will come out over the next few days on a range of other matters and environmental matters. But I just want to get a feel for your take on this overall view that the applicant's made. So I will start with Dumfries and Galloway Council, please.
Thank you, ma'am. I'll begin with a summary. Just looking at the 10 points. We don't support points 3, 7, 8, 9, or 10. Sorry. 3, 7, 8, 9, and 10. So the summary, therefore, we don't consider it to be sustainable development. But just if I can just briefly go through the 10 points. Looking at point number 1, we would agree that it would deliver some socio-economic benefit. Looking at point 2, I wouldn't say that the implementation of the proposal would assist massively with local economic strategies. In some way it would, and when we look further into the EIA in terms of sort of jobs and the things round about the sort of the local economics of it, it's the similar language that we see across developments of this type. It could create so many jobs, or it could create this. So we do agree to some extent that that it would, but not to a massive extent. Point 3, we disagree with, as I mentioned. We don't think that it contributes to a sense of place. It's poorly cited large-scale industrial development, which is out of character with the landscape. One of the reasons we gave for objection to it was on the basis of OP2, which is our placemaking overarching policies. So that makes sense that, that those two align with each other. In terms of point 4, yes, we would agree that it supports the delivery of infrastructure, particularly it would require a grid connection. Point 5, support and climate change. Yes, it would support mitigation in the broadest sense of that. Point 6, it's not clear really what Mr. Bell's trying to take from this. It's yes, we can. If we look at the where are we? The benefit of the proposed development will be the provision access to tracks for recreational purposes. I don't know if that's meant to be the provision of access to tracks for recreational purposes. If that was the gist of it, then we would agree to that one. But maybe just like a wee bit of clarification on that particular sort of point going forward. Point 7, whilst the proposal would support and contribute to climate change, it doesn't have any regard for landscape factors, and we don't consider it to be sustainable land use. Point 8, we don't believe it contributes to the protection of cultural or historic environment, and we disagree with the assertion that it's not particularly relevant. Point 9, it doesn't protect the wider landscape. Our objection notes conflict with LDP2 policy NE2, which is to do with regional scenic areas. And the final point that we have in the table, a smaller scale scheme would have been possible on the site. So the proposal as it stands is overdevelopment. If a smaller scheme couldn't be found, one tends to lead to the other. With that, that's all that I have on those 10 just now, ma'am. Thanks.
Similarly, could Scottish Porters Council give me their views? Thank you.
Yes, very similar to Dumfries, unsurprisingly. We agree with some points, but not others, and the ones we don't agree with are the same points that Mr. McTeer has raised. So that, again, that's point 3, 7, 8, 9 and 10 as well. I mean, point 3, we have objected on grounds of adverse impacts on the landscape character. At point 7, acknowledge that the land use strategy recognises wind power as an important source of renewable energy. It appears to defer to SPP that wind farms should be promoted in locations where the technology can operate efficiently and environmental and cumulative impacts can be satisfactorily addressed. Within our recommendation, we found that wasn't the case at Fosside, where there were landscape and cultural heritage impacts. Point 8, again, we raised an objection based on cultural heritage impacts on the setting of Pikethaw Cairn. At point 9, yet again, landscape tensions which were accounted for in the objection, and point 10, yet again, overdevelopment of the site. We found the size and scale and design of the proposal, found that the development was too large for this particular location.
Thank you. Mr. Campbell, Foresight Community Group, do they have anything they want to say on this particular issue?
Yes, ma'am. I particularly picked up, you asked for points of particular difference between parties. I particularly picked up on points 4, 7 and 10. My view is that it doesn't make efficient use of infrastructure, of existing infrastructure, essentially because of we're back to the oversupply problem and the fact that the energy can't the place. There will be a grid connection to Teviot Head, and there is an existing line running through there. But if you look beyond that, there is a major problem with the infrastructure, and therefore it's not making sensible use of existing infrastructure. It's actually overloading it. In terms of point 10, avoiding overdevelopment, I'm sure we have a nice succinct definition for overdevelopment in Scottish planning documentation. But I take it as being referring to the amount of development that is in excess of...
Second, Mr. Ford.
Let me just switch.
Mine's off.
How's that? Sure.
Thanks, Graham. Sorry to interrupt. It was just
That's
crackling
okay.
quite a bit there.
We're back to normal sound service. Good. So I was saying that there isn't a general definition, I don't think, in Scottish planning documentation about what overdevelopment is. But I've actually taken a phrase from UK English planning documentation, which talks about the amount of development that is in excess of the terms of demand on infrastructure and services. So obviously, in this sense, because of the grid issues, we are back to that situation. It's interesting to note that Mr. Bell doesn't actually really deal with this in his hearing statement. He simply points off to the EIA. With all due respect to him, I don't believe the EIA in any way kind of answers that. So it'd be interesting to hear if you've got anything positive to say to that. In terms of point 7, does it support climate change mitigation? It would if the energy could be used, and I would be content to support it on that basis. But because of the oversupply situation, it doesn't make a contribution to climate change mitigation, and therefore we are in dire straits with that situation, and that, I think, is the most crucial reason why it isn't in this particular proposal, is not sustainable development.
Do you mean 7 or do you mean 5 or do you mean 5 and 7?
I do mean 5 and 7, Mum. I was particularly looking at Mr. Bell's responses. That's why I got onto climate change there. Thank you.
Okay, thank you. Mr. Bell.
Thank you. I think as a preamble, the principles are to be applied to all development. I think it's important to retain that perspective. So it could be a caravan site, it could be a hot food takeaway, it could be an industrial estate, or indeed a wind farm. And the guiding principles are there to be taken into account, but the position I would take is that it's not a matter of according with each and every one, it's a view in the round, and there clearly may be development, not just wind farm development, that are generally consistent with most principles, but maybe not all of them. In terms of the first one, net positive socio-economic effects, I think there'll be more said on Friday about that, and linked to the second point about challenges and issues within the rural economy in this part of Scotland. More will be said on Friday. I think Council's perhaps being a bit dismissive about that. I think in an environment with public spending pressures and the only real sector of the economy that is delivering substantive public and other benefits in this part of both authorities. Again, more will be said on that on Friday, and the importance of that. The third point, in terms of good design, I think, again, in terms of the applicability of design, that's clearly relevant, but has to be viewed in the context of the 6 qualities of successful places set out in SPP in terms of the urban design approach to distinctive places and placemaking to a large extent. So the point the applicant would make in terms of the applicability is achieving a satisfactory layout with regard to the various environmental considerations, in particular landscape and visual, that will be covered in the landscape evidence. Fourth point, I think there seems to be consensus on that in terms of energy generation, with the exception of the community group. The fifth point, likewise, seems to be consensus on that in terms of climate change action and flood risk has been addressed in the EIA. The sixth point about health and well-being, just to clarify, there is to be assured access on track systems for recreation. So in terms of Mr McTeer's query on that, I've also highlighted in page 25 of my hearing statement that the onshore wind policy statement draft highlights the recreational provision opportunities and Whiteley, for example, for horse riding, cycling, mountain biking, running, 10Ks. There's a whole range of activities that go on. Not every wind farm, but I think the larger scale ones offer real opportunities for that and to link into other path networks. And apps like Strava have shown the frequency in which, in particular, mountain bikers use some of the systems. They're not for everybody, but they are a resource that could be marketed as the way in which Whiteley is marketed. Number 8, in terms of cultural heritage, it is clearly relevant, cultural heritage, and that evidence will be heard. What I've said is the proposal would not hinder access to cultural heritage, and indeed there could be interpretation and greater promotion of that made. But we acknowledge that there would be some effects on cultural heritage. Protecting and promoting access to natural heritage. Again, in terms of access, that would be provided, and it's a matter of protecting insofar as the EIA demonstrates that there would be no unacceptable effects arising. The 10th matter in terms of overdevelopment, I think that's probably more aimed at typical urban development when it talks about protecting amenity of new and existing development and considering environmental implications. But those matters have been addressed in the EIA in terms of the various topic chapters. Thank you. I should say the overall conclusion that the applicant has is that the proposed development in the round would be consistent with these policy principles. And when that is married with what is in effect a Group 3 area, namely the site can be regarded as Group 3 having satisfied the Group 2 matters, that is a supportive position.
Can I just clarify with you, Mr. Bell, that Principle 8, where you say this principle is not of particular relevance to the proposal, are we striking that? I'm happy with that. Yeah, to strike that out. Okay, moving on now, on to a final matter under this topic, which is, it's not something I want to get into too much detail on, but I wanted to raise it as it had been raised by parties, and it's about grid capacity matters, which was referred to in paragraph 165 of Scottish planning policy. And it was raised as a matter that might need some discussion as to the relevance and the applicability of that paragraph and how it's being applied in recent decisions. And I refer to two called-in decisions in Orkney, referenced there in my note of the agenda. So, Mr. Ford, you've raised this particular point. Would you mind going first, and then I'll ask the applicant to respond?
Surely, Ma'am. Thank you. If you look at paragraph SPP 165, excuse me, it opens by referring to grid capacity. And obviously it says that this should not be used as a reason to constrain the areas identified for wind farm developments or any decisions on individual applications for wind farms. So at first sight, that seems pretty clear. But it goes on to qualify this by talking about, quote, it's for developers to discuss connections to the grid with transmission owners. So perhaps that's not so clear. Close scrutiny of SPP 165 shows that it's really only talking about the local or the immediate connection from the wind farm to the grid. It does not include any wider issues relating to grid capacity. 165 does not have anything to say and does not apply to or exclude consideration of wider grid issues, such as grid capacity between Scotland and England, or anywhere else for that matter. We can see this because in the final sentence of 165 it says, quote, consideration should be given to undergrounding grid connections where possible, close quotes. So the scope of 165 is really limited to the immediate connection between the wind farm and the grid, in this case between the proposal on the hill, if you like, and the substation at Teviot Head. It has nothing to say about grid matters beyond this first connection point. So contrary to what Mr. Bellis suggested previously, and no doubt will today, and actually has earlier on today, suggested 165 does not provide a universal prohibition on consideration of wider grid matters from these proceedings. To me, 165 would be clearer if it started by saying local grid access should not be used as a reason, because that's really what it means, and I believe that's what it's about. Just by way of background here, if we go back, it may be useful just to explain that as well as Section 36 consents under the Electricity Act, wind farm developers need to obtain consent to be able to connect to the grid and to use the grid. That means the developers need to sign up to the Connection and Use of System Code, the CUSC, set up under the Electricity Act to regulate the industry. Properly licensed operators can obtain a connection to the grid anywhere in the country. Perhaps surprisingly to lay people, there's no legal constraint on that. So if a developer wanted to get grid access on top of Ben Nevis or Cairngorms or Snowdon or Wales or any of the local hills around here, the transmission owner will be legally obliged to provide that. I'm aware that the applicant has actually gone through this process for this proposal. After a proper application to National Grid, in which they gave the development location and the required connection size, which is in megawatts, the developer was offered and is offered under the standard contract, a binding contract with, and there's 2-3 points in this. First of all, the cost of the local connection. Secondly, the enabling works that need to happen beyond the local connection to enable the grid to facilitate things. And whilst this doesn't apply in this situation, it often does in other situations. And then thirdly, the first possible date for the connection to be able to operate, which is usually some years ahead basically, and will often be dependent upon what are called in the jargon enabling works. So this might be works that are done anything from a kilometre away to tens of kilometres away basically. As we say, in this situation it doesn't apply, but in many other wind farms there are those enabling works. So in practice, due to the cost and the timing of possible local connections and enabling works, developments tend to take place and cluster around electricity substations. So in relation to SPP 165, the point of this explanation is that there is always a possibility of connecting to the grid anywhere in the country. So that historic problem, if you like, of some contention, and we have to remember that SPP was written in 2014, but historically there was always some contention around whether or not a grid connection could be made. So essentially, a grid connection can be made, and in a sense, SPP 165 is actually, in a sense, not relevant anymore. And it's also worth mentioning that the equivalent paragraph is not reappearing in the draft MPF 4 as well. So this, when the MPF 4 comes into power, this paragraph will actually fall away. But in any event, it doesn't essentially stop discussion of it really only focuses on the local connection between the power generator and the local grid. In terms of the Orkney decision, first thing to say about that is obviously it's subject to judicial review and therefore is not finalised. Oh, I'm told it's a statutory appeal. um, um, but my understanding of the issues under contest there is that they're not actually discussing. Oh, sorry, I should just explain what the Orkney decisions do, which is essentially what's happened in the two Orkney cases is that the Scottish ministers overturned recommendations to refuse by the reporter, and there's a lot of debate about the connection between Orkney and the mainland. I won't go into the history of that, Ma'am, but I can do if you want me to. But essentially, it's very obvious that the Scottish ministers overturned the reporter's recommendations because of the issues around the grid connection between Orkney and the mainland. So in a sense, the Scottish ministers have demonstrated that grid connections are important. In that case, it was a positive support because they wanted the developments to go ahead to support the proposal. But the point is they are considering grid connections beyond the local connection. But as far as I understand the issues of contention there, those are not actually the issues that are actually being challenged under the statutory challenge, under the judicial review. Thank you.
Those appeals are being heard in October.
Thank you. I didn't know when they were being heard. Mr. Bell.
Thank you. The applicant's position is that paragraph 165 of SPP is very clear, that grid and related wider grid network matters are not relevant to the consideration of the application. I can't think of one appeal or Section 36 decision, or indeed a local authority report on handling, that has raised that matter as a determinative issue in any case. So there's been a consistency of following SPP position, which we say is expressly clear. For Mr. Ford to say that the exclusion of the paragraph from NPF 4 means that the ministers now view that as a material matter, we do not accept. And we've discussed in any event the fact that NPF 4 is still under review and we haven't seen the finalised wording of it. In terms of the Orkney decisions, it's quite a unique situation there. And the interconnector to the mainland, now I know Orkney well, having working on schemes, and the interconnector is fundamental to delivering the energy from there, as it is on Shetland for the Viking scheme. And if one looks in it to the wording of these ministers' decisions, so in terms of Quaternass, which is CIN ORK 001, paragraph 18 of the minister's decision letters refers to imperative reasons of overriding public need, which is related to the needs case for an electrical interconnector, which represents sufficiently exceptional circumstances and overriding public need. It goes on in that paragraph to refer to the needs case as set out by Ofgem for the interconnector. And then at paragraph 25, the interconnector in that case was a national development set out in NPF 3. So there's a direct planning statutory basis for the interconnector and its need case, which is a given in NPF 3. And the ministers go on in paragraph 25 to say that not to approve the scheme could be ultimately fatal for the interconnector needs case. In paragraph 33, on the separate decision, that's ORK 002, the ministers say that without the development, there is no likelihood of this 135 megawatt target being achieved. That is to trigger the threshold for approving the interconnector. So we would say that there's only two decisions being referred to in terms of the grid matters. They are distinctly different from the position that we're dealing with in this case. Thank you.
don't want to get into a debate, ma'am, about another case, but if I may, the points made by Mr. David Bell are both under challenge in the appeal. I'm the responsible person for the appeal, so I kind of know this, and I don't want to litigate them here, of course, but you should know that these are points in issue, not givens, if that's a word, in terms of the ministerial decision.
Okay, I can look into the actual latest appeals on these and see what the situation is. I'm going to suggest we have a short break and come back at 3:15, so just a 10-minute break. Thank you. Okay, can we start back? Just to advise that the updated core documents list as of 28th of June is now available on our website. So that should have all the links embedded within it as well. So you might want to pop that onto a USB stick or something that might help tomorrow as another backup. Okay. I'm trying everything. Right, back to the agenda. Moving on to the development plan. And this is the final section, really, just to explore with the councils and other parties just their views on the relevance of various aspects of the development plans. And I'm going to start off with Scottish Borders Council. And given that the development plan is now more than 5 years old, I believe, could you explain to me the extent to which paragraph 33 of SPP, Scottish Planning Policy, which refers to the presumption in favour of development that contributes to sustainable development, how that would apply?
Thank you, ma'am. Yes, certainly it is now more than 5 years old. I think it's worthwhile to note that at the time of the consultation to SBC, our assessment and recommendation was undertaken at a time when the LDP was still within its 5-year period. As I mentioned, we do acknowledge it's now more than 5 years old. Despite this, we don't believe that it means that the development plan should be set aside, and that is not, and that isn't really the intention of paragraph 33. The reason for that is because we believe that the benefits of a scheme should still be considered against the wider policies within SPP, given that SPP is still current and our LDP was adopted at a time following the confirmation of SPP. We believe it still remains robust and relevant to the application, and in spite of that, it would be unreasonable to dismiss the LDP and offer automatic presumption against it. Thank you.
Can I just ask you another question, really moving on to point 3 there? So the emerging development plan that you have, just tell me what status that is at and where is that?
I understand that it's now going out for examination. I think it would be unreasonable to try and argue that it should be given significant weight. I think it's still at a time where only limited weight could apply to the development plan. I think it is worth noting that I think the most relevant policies, policy ED9, which considers obviously renewable energy development, that in the current LDP of 2016, that featured in the plan following kind of extensive work by a reporter at the time, and there's only a fairly minor change to that policy that's been proposed in LDP2, and that is for considering wind energy developments, and that's the addition of a separate consideration for aviation lighting. in terms of amenity impacts and visual impacts. Other than that, that policy is largely the same. However, it still needs to go through the process, so it's fair to say it could still be subject to change. And similarly, policy ED8, which covers archaeology, that very much follows what's in the current 2016 LDP, but yeah, obviously caveated with the same reasons as I just mentioned.
So can you just clarify for me, both ED8 and ED9 are both subject to representations unresolved and are going to be...
That's correct, yes.
Mr. Bell, do you want to talk at all about the applicability of paragraph 33?
Yep, thank you. I would maybe start off by saying that the position has changed since the Glenshero decision. I think there was general consensus that the presumption in terms of paragraph 33, in particular the tilted balance, would not apply to an Electricity Act case. I think it was explored in some detail at Windy Standard, I remember, and that seemed to be the result that came out of that was then commonly followed throughout Scotland, actually. And I think it was quite a surprise when the Glenshero decision came out last year. The ministers had applied the tilted balance in their decision-making. So certainly in cases from beyond that have been going to the ministers, I have examined it and applied it to some extent. We'll come on to the extent, though. But clearly in a planning Section 25 case, it would be applicable, and we know the South Kilbrowre appeal decision has been challenged and not contested because of that failing. But I do think the position is different in an Electricity Act case, and I have referenced how it would apply in my hearing statement. As Mr. Shearer was saying, I don't think it's a matter of setting aside the development plan. I wouldn't go as far as to say that, and that's certainly not what the applicant suggested. But it's the reference to where the plan is 5 years old or more, then the presumption is a significant material consideration, and the test is, would the effects significantly and demonstrably outweigh the benefits when set against the wider policies in SPP. And it's clearly difficult when you have a situation when an application straddles two planning authority areas and there's different development plan positions. One scenario might be, do you do a forensic analysis and apply that test just to the effects that are arising in that area? I would say no. There is a matter of, in an Electricity Act case, taking cognizance of the development plan, but we know there's no primacy, and it needs to be looked at in the round in terms of a planning balance, the harm against benefits. And the development plan is informative, but is not, we should not feel constrained or bound by the plan as if it was a Section 25 case. So I would say, to conclude, that technically, given Glenshero, the presumption is a material consideration, but legally it does not bite. And I would say that there is a strong case for the development on a straight reading of policies as they stand at a national level, SPP and the development plans, without applying what would be known as the tilted balance. And that's the approach I've taken, although I've acknowledged it is material, but there may be a legal view to be given on that in terms of the Electricity Act case, and given the position that the ministers took in the Glenshero decision.
Mr. Armstrong, do you want to come in?
Yeah, Ma'am, I'm happy to sort of set this out in the closing submission, our closing submission in relation to the legal position, but the Council's position remains, as it was put in the Windy Standard case, that the tilted balance does not apply here because of the statutory status of the development plan.
Does anyone else want to comment on that particular matter? Mr. Campbell.
I think we agree with that.
You think you do or you do? You do agree? Okay. Yeah, the applicant raised a point there about how to apply the relative balance. This point 2 in my note of the agenda, in terms of the above points, and where you've got 2 council areas with differing development plan age status. You suggested there that you don't look individually at each one and you apply a kind of wider, a kind of overall view of that. I just want to ask if that's something that sounds reasonable from the council's point. It's hard for you to comment because you're dealing with your individual view, but just could you turn your mind to the fact that you could look at, in my position, what I would need to do? First of all, I'll start with Mr.
McTeer. Respectfully, that's for the decision makers, I suppose. I don't envy that particular job. I suppose we've looked at it in terms of our own area. The bulk of the development is within the Dumfries and Galloway area, so the bulk, particularly of effects, would also fall on us too. So from our point of view, LDP2 is particularly relevant to the decision making process. But in terms of the weight given to that respectfully, ma'am, is for you.
And Scottish Board.
Thank you, ma'am. Yeah, difficult one to answer. I would certainly agree with Mr. McTeer that the majority of the development is within Dumfries. That said, there are 13 turbines within Scottish Borders area, and there are 13 tall turbines as well, up to 200 metres tall. I fully understand your position in terms of taking a step back and maybe trying to look at things slightly more holistically rather than needing to drill down to every detail within every plan. I don't know the relevant policies to Dumfries well enough to make any comment on those, but I would like to imagine that, given that they have been through relevant examinations by a reporter against SVP, granted ours is older than theirs, but I'd like to think that there is a fair amount of dovetailing with those policies. Thank you.
Mr. Campbell.
The 5-year limit, which brings the tilted balance into play in Section 25 cases, that 5-year figure is that 5-year date is just an arbitrary figure. It's just a cut-off figure, and it's not put there because of any discernible planning reason. So you're asking for help. If I was trying to give you help, and I do that with the greatest respect, of course, you would look at the development plan, which is more than 5 years old, and see what it says. You would then look at its replacement at whatever stage it is and see if they're different. And if they're not, then your job is done. But if they are different, you have to weigh between the two, and that's a job that I think you can only do yourself. So far as the other authority is concerned, if it's not more than 5 years old, then it applies. And perhaps obviously it applies. And so you're able to take its terms and apply them to your own planning balance. I'm sorry that's not terribly helpful or very well put, but it doesn't seem to me to be insuperable as a problem.
Thank you. Mr. Bell.
One brief point. I think there is a discernible planning reason for the 5-year period. It's in the development planning regulations in terms of the life of a development plan, and there will be some basis behind that figure. The questions will be, when a plan is of that age, how does it relate to national planning policy? That's part of the presumption in paragraph 33, to look at whether the policies are out of date. I don't think there's much disagreement that the policies are generally still consistent with SPP. But that is what I would say is the 5-year reference.
The board, yeah.
The 5 year is an ambition, ma'am. So, you know, it's nominally set there, but there's lots of planning obligations that we don't meet. Port Dumfries and Galloway Council are overloaded with wind farm applications and not able to keep up with it and so on. So, you know, there's a difference between, what I'm trying to say is there's a difference between the hope and expectation in policy and the practical. My best advice is my professional sympathy to you, ma'am.
Okay, moving on swiftly. I'm going to move on to talk about the landscape capacity studies of both the councils, and there's various statements made. So I understand, you know, both councils, and correct me if I'm wrong, agree that it's still a matter for an application, the merits of the application to be considered, and the landscape and visual impacts to be looked at on a case-by-case basis. There's different statements made in the councils between what they consider the status of the capacity studies and their applicability. So I'll maybe just touch on some of the statements. First of all, Scottish Borders. And under, I think it's paragraph 3.26 of the statement. I think you say that the capacity study fills the intermediate role between the national policy generic guidance and the detailed assessment of a specific application. It is emphasised in the document that it is a strategic level landscape and visual study, and no site-specific conclusions should be drawn from it in relation to the current proposed or future wind energy schemes. However, it can provide a wider and more objective context for considering the capacity for and the accumulative effects of existing and potential future wind turbines in the Scottish Borders areas than would an individual LVIA. And I suppose I just wanted to explore that final point that's been made. Are you suggesting that it's almost suggesting that the assessment that's done in an LVIA doesn't actually have as much relevance, and this capacity study has more relevance in terms of what I take on board? But could you clarify that for me?
I don't think that's the point that we were trying to make there. I think what we're trying to say is that it's the capacity study. It's a good start point. It should help to guide proposed developments as best as possible. We would expect an LVIA thereafter to then drill down to the more detailed considerations, but importantly to respond to those more general guidance that has been undertaken at that capacity study.
I suppose I'm just trying to understand what you mean by strategic level landscape and visual study. Just provide a little bit more on that. So, just given that it contains quite a lot of detail, you know, the capacity study it itself drills down to quite a lot of detail. So how do I take a step back from that and identify it as a more of a strategic level study?
Well, I suppose it gives a broad range of landscape constraints that should be considered with the proposed development. Those constraints are broken down to different character areas, and then that was then used to inform turbines of specific scales, which may or may not be suitable in certain areas. Thank you.
Just staying with you if I could. At paragraph 3.32, you talk about while it is knowledge that the capacity study identifies a capacity for turbines over 120 metres in height, presumably this is only at a low capacity, and this proposal is seeking consent for a number of turbines with a 200-metre tip height. I wonder if you could explain to me what you mean by the statement this is only at low capacity.
Well, the capacity study, I suppose what that would have done is it would have undertaken a landscape assessment into what may be appropriate within various parts of the Scottish Borders. within the location of Fosside. That information was considered by our landscape consultants at the time to allow for a low capacity for turbines that were over 120 metres in scale. There were other ranges that were also perceived to have potential, where there are areas of medium and areas of higher capacity as well, and also areas of no capacity. And so in that sliding scale, if you like, the Fosside development was found to have a low capacity for turbines over 120 metres in height.
Okay, thank you. Is there anything more you want to add on capacity studies before I pass this round to others to comment?
Yeah, I think a point that we made during I think it was initially raised in the consultation response of forward planning colleagues, and it featured in the landscape architect's comment, and also it certainly featured in the report of handling as well, was a point about the height of the turbines being 200 metres tall. Now, the capacity study was undertaken in 2016, if I recall rightly, and at that point in time, 120 metres was quite a big turbine during that period. Subsequently, we have, I think it's fair to say, that the scale of wind turbines has got larger and larger, but the relevant guidance that we can use is not quite kept up with that. The capacity study provides coverage on different scales of turbines, and it kind of jumped up in about distances in terms of metres of about 20 to 40 metre kind of typologies. So well, it does say over 120 metres. I do not believe that the jump to 200 metres is really accounted for in that capacity study, because we, at that point in time, we weren't receiving applications for turbines that were 200 metres to tip. We certainly are now, but not back in 2016. Thank you.
Mr. McTaker, do you want to come next?
Thank you, ma'am. In terms of the sort of the weight and status of the capacity studies, my notes start with considerable weight, which is unsurprisingly the position that we have. The DGW-LCS is appended to our supplementary guidance. Kind of going to the development plan itself, paragraph 4.108. To do with policy IN2. Sorry, go ahead.
Paragraph 4.108.
Yep. So it states that policy IN2 is supported by supplementary guidance, which has obviously since been adopted. The following paragraph, 4.109, states that the DGW-LCS is attached to the supplementary guidance as an appendix. In this case, it's Appendix C. Further back in the LDP2, within the natural environment landscape section, paragraph 4.57, it states that the DGW-LCS builds on a previous landscape assessment and should be used in relation to all wind energy development. Within policy IN2 itself, on page 70 of the development plan, in relation to map 8, which we spoke about earlier on, as that's the spatial framework map, it states quite clearly that the map must be read in conjunction with the DGW-LCS. Within the Council's adopted supplementary guidance, paragraphs 1.3 to 1.4, states that the DGW-LCS is attached as an appendix to that. Paragraphs 2.2 to 2.4 set out the special framework and notes again that the DGW-LCS providing guidance on development. It is a very detailed guidance document. Within the development management criteria in the supplementary guidance, section C, which covers landscape and visual impacts and design of proposals, paragraph C3 states that the DGWLCS, it's a mouthful I know, contains detailed assessments of landscape and visual sensitivity, and that potential wind energy developments will be required to demonstrate how they've taken into account of and responded to the assessments and guidance contained within the DGWLCS. More widely, recent decisions at Cornharrow and at North Lowther support our view that the DGWS forms an intrinsic part of the development plan. It's been through the same process and subject to the same public scrutiny as the rest of the plan, and we consider 100% that the capacity study is part of our development plan and supplementary guidance. Thank you.
Which is Cornharrow.
North Lowther, ma'am.
Ma'am, just it's CD reference 1547, and the paragraphs where that's the reporter's report, and it's paragraphs 3.189 to 3.197, and the conclusions of the reporter at paragraph 3.333, which were all subsequently adopted by the Scottish ministers, sets out the approach that we say should be followed and adopted in relation to the DGWLCS. And at Cornharrow, it's core document 1517, because there's obviously two decisions in that, and it's two decisions in relation to Cornharrow, and it's the CD 1517 one, and it's paragraphs 27 to 29, where the reporter deals with these matters.
Okay, thank you. Mr. Bell, do you want to come back on any of the points that were made there about, or Mr. Hardy, sorry?
Yes. I mean, these are all tools, aren't they, in order to help the decision maker. I think just in providing a hierarchy, of course, we're dealing with the factors in Schedule 9, Paragraph 3, Schedule 9 of the 1989 Act. That's the starting point. The second point, then, is, as we've discussed in other contexts, then the position, then, of the development plan itself. Coming down a level, these are subordinate documents, and principally, just talking about D&G for a second, they are subordinate documents. They're clearly referred to in the development plan, but they are secondary documents. There's no express requirement in the development plan to follow what's in the capacity study. They weren't subject to the same degree of examination, contrary to what's been submitted. And then finally, they, as we will discuss in the landscape sessions and indeed in closing submissions, the submission will be that there is reduced weight to be attached to them insofar as the two capacity studies are inconsistent with the most recent Nature Scott draft landscape sensitivity guidance. And I mean, put shortly, it was a matter that we've discussed in other inquiries with common parties, the other parties in the room, that we say there's a move away from the matter of capacity to dealing with matters of landscape sensitivity, and we say that both of these documents fail against that guidance. So that becomes a matter of weight. So coming down that hierarchy, yes, they are all, they're in the mix, they are tools, but the weight when set against the task that you're asked in the 1989 Act is a much lower level of weight and relevance to decision making than is suggested by either of the councils. So definitely some weight, but a much lower degree of weight, would certainly distinguish ourselves from the high degree of weight that D&G suggested.
Thank you, Mr. Hardy. Anybody want to come in on that? Okay, I've got parties' positions on that. Okay, just moving on. This is an issue that I brought up, but actually it's probably, and I remember we discussed at the pre-examination meeting that policy matters dealing with cultural heritage would be dealt at the cultural heritage session. So I'll just touch on this, and it's perhaps an issue that will be brought up in our August session, virtual session on cultural heritage. So I think it's a point that the applicant has raised in Mr. Bell, in your statement, that Scottish Borders Council's policy EP8 dealing with archaeology and Dumfries and Galloway's council policy HE3 dealing with archaeology as well. I think they're both titled archaeology. I have to correct that. Are not consistent with SPP paragraph 145, and so I want to just explore that with the councils themselves, appreciating that probably don't want to get into too much detail because it may be that we'll go into more of that at the cultural heritage session. But given that I've got two people here who have maybe got policy background rather than are going to be involved in the cultural heritage inquiry session, who are might be more detailed into the cultural heritage matters and will witness this with councils, I'd want to explore with the policy people here what your views were on that. So I'll start with Mr. Shearer from Scottish Borders.
Thank you, ma'am. So my understanding that the main difference is in SPP reference is made to integrity of setting, but in our policy EP8 the reference is setting. I mean, I think it's quite a difficult thing to actually speak about and actually consider as well as setting. It's hard to define, and I think then I suppose I kind of don't want to answer your question with the question, but I'm not too clear on what the difference of integrity of setting and setting actually kind of maybe could be. I guess that our policy went through examination, presumably that was against the SPP, and it was obviously it was accepted through that process, so it must have been found to be considered the relevant criteria. But yeah, I think we have coverage of setting within the policy. We are looking for something more than what SPP looks for.
Answer your question. I'll try and explain. Yeah, it's just really just understanding the exceptional circumstances which they are in relation to scheduled monuments, which is what paragraph 145 talks about. I appreciate the integrity of setting. That is a matter that will be explored in detail, I'm absolutely sure, at the cultural heritage session, and what we mean by setting in relation to the scheduled monuments. But there's exceptional circumstances. Just whether the policy fits with that. I'll maybe ask the applicant to come in a moment just to clarify what their concerns were about it. Can I move on to Dumfries and Galloway and just ask you to talk a little bit about your policy, and then I'll move on to the applicant.
Thank you, ma'am. Yeah, it's. I mean, appreciating that this is likely to be something that's the subject of the further session, and the council's archaeologist would be the sort of best qualified to look at that one. In terms of the sort of the wording of SPP 145, as has been mentioned, it's to do with an adverse effect on a scheduled monument or on the integrity of its setting. Now, looking across the whole sort of section of SPP that relates to cultural heritage, paragraph 145 is the only case where the word integrity is used, and as far as we're aware, neither the Scottish Government nor HES have provided any sort of guidance on the meaning and use of integrity in that particular context, where guidance on setting, there's plenty of guidance on that. So, the exceptionality of the word, integrity, doesn't really comply with the sort of the broader thrust of historic policy within SPP. I mean, looking at the sort of the key opening or the key opener at paragraph 137, gives you a sort of list of everything the planning system should do, from, promote the care and protection of the designated and non-designated historic environment. And it goes on to list, individual assets, related settings, and the wider cultural landscape. So our policy, HE3, we believe conforms with the policy principles set out within SPP. As I say, I think it's going to be one that we can explore in a bit more detail at the session in August. But it's it does seem to just refer to scheduled monuments, but we apply a sort of clear assessment of all historic sort of matters within our assessment of these things within policy HE3. Thank you.
Ma'am, I should say that at the next session dealing with this, it was the intention to go in to deal with the application of the policy and how that fits in with the paragraph 145, and in particular also the guidance from Historic Environment Scotland and their recent guidance on that.
Just to move this point, I think it's probably not going to get much further with this with the witnesses today. It's probably better that we deal with it. Is there anything you want to add, Mr. Bell, just before we move on to the next item? Oh, Mr. Hardy, sorry.
Not really, but just to reference again, of course, paragraph 3, Schedule 9, which adds the text really desirability of preserving and protecting sites, buildings and objects of architectural, historic or archaeological interest. So under the Act, that's the highest order. I think there, in relation to integrity of setting, there is a working definition of that which is being discussed between the applicant and HES, and that will form the subject of discussion at the session. I'm not sure we need to take it much further today. HES will say that there is something particular about integrity of setting, others will disagree. What we really say is you should be concentrating on the substance of the impact on cultural significance, which is enshrined in the various assets. That's the test.
Okay, thank you. I'm going to move this on to part 6. So this is moving into the Dumfries and Galloway's policies, particularly looking at OP1 and OP2, and just trying to understand how I bring them into the considerations of this particular proposal, bearing in mind this is a Section 36 case, but I understand material considerations will be the development plan. And how they tend to operate in practice, just so I can understand. And there's a lot of, I'm not suggesting we go into all those decisions that are there, because they've been used in various aspects of those different decisions. But if you just explain to me a little bit about how those policies kick in for a development of this type.
Thank you, ma'am. Our position is set out in our hearing statement, paragraph 6.3.5. I suppose the clue is in the name. OP it's an overarching policy. There are 3 of them in the LDP2, so they sit as an umbrella over everything else. That's how we look at them as overarching. Right at the beginning of LDP2, paragraph 4.1 states that all development proposals will be assessed against these policies where they're considered relevant, and I suppose relevance is the kind of the point that we would I would highlight here. OP1C, Part C, specifically refers to landscape. OP2 also includes landscape considerations and references a sort of positive contribution to local distinctiveness. If I can just point at a couple of the decisions there within the agenda. The Glen Shimmerich decision, so that was PPA 170-2138, which is core document 15.016. paragraph 75, the reporter covers both OP1 and OP2 in the section. The section is titled Compliance with Development Plan. So the inclusion of those in the decision-making sort of process of that particular reporter, I feel, is one that's worth pointing out. The other decision that I would look at is 170-2040, which is the one at Cornharrow. Now, the reporter does note that he feels that, or they feel that OP1 and OP2 appear to be directed to proposals for built development. Now, going back to the paragraph 4.1, to what we consider development, I mean, we would consider a wind farm to be built development. But I would say that there's not, I don't think there's that much between our evidence on this matter, between ourselves and the applicant. That's really all I've got to say on that particular point just now.
Mr. Hardy, anything you want to say on that? No. Mr. Bell?
Just briefly, I think I've set out the decisions, and the consensus views of the reporters has been there's more relevant policy guidance in policy IN2 and IN1. So there's limited applicability or utility from these higher level policies, although technically they are relevant, as Mr. McTeer says.
Right, I think I have enough on that. I don't know about else, but I've lost Wi-Fi connection again, so struggling to get open things. Finally, I have a final item here is in relation to the regional scenic areas, just to enable and help my understanding of regional scenic area designation in this part of the world. I understand part of the site is covered by the regional scenic area, and what I want to explore is how that particular policy kind of operates in practice, and particularly with regard to a wind farm development. What does it say? What is the intent behind it? And how do you then apply that to this particular proposal? So I'll to you, Mr. McTeer.
Thank you, ma'am. Yeah, the sort of the application of policy NE2, or certainly NE2, more generally set out in the hearing statement at 6.36 to 6.39. We have a regional scenic area, a technical paper, which sets out the qualities for which the various RSAs across the region are designated. The one, or certainly one recent decision that I would point to, again, is the North Lowther decision, page 96. Paragraphs 3.228 to 3.2230, where the reporter goes through the special qualities that would be significantly affected by that development. So different RSAs obviously have different qualities for which they're designated. Looking through Mr. Bell's report at page 98, we don't believe that it addresses the designated or the designation factors. Rather, it looks at the integrity of the landscape character that underlies the RSA itself, rather than looking at the...
Sorry, Mr. McTeer, sorry, can I interrupt you? You just said looking at the applicant's statement. Can you just clarify where you're looking at in terms of the statement?
Page 98.
The statement doesn't go to 98.
Does it not? Sorry. Just maybe... hang on.
I think, ma'am, to assist it, it's pages 47 and 48, paragraphs 5.2.24 through to 5.2.28, where Mr. Bell addresses this point but doesn't deal with the test in NE2.
Yep, apologies for the wrong page reference there. Really, I just wanted to close out the point on NE2 in the Chapter 6 conclusions of the EIA. I submit it does note that there are it does conclude that there is a significant effect on the reasons for designation, or at least part of the reasons for designations of the RSA.
Mr. Bell, do you want to come in on this?
Yes, thank
Final
you.
points?
In terms of the policy, the starting point would be the policy doesn't prevent wind farm development, and a local landscape designation doesn't feature in the Group 2 considerations in terms of the spatial framework. And I think there's common ground that there are numerous wind farm developments that have been consented within such designations, and indeed within both authorities, I think, as well as further afield in other planning authorities. In terms of the policy, what I have set down is the references drawn from Mr. Welsh's evidence in terms of the fit of the development, and that will come and be explored in the landscape evidence shortly, in terms of the effects that Mr. Welsh finds on the key characteristics of the RSA, insofar as he's identified those. I think also it's of note that there's no balancing mechanism at all in the policy. It's simply a matter of whether or not there would be significant adverse effects referenced. So the approach would be to look at what are the landscape characteristics and balance harm to form a view as to whether or not the development can be successfully accommodated. And that's the approach the applicant has taken.
Would you say that's an approach that's consistent with what other reporters have done in relation to this policy, in your experience?
I would need to look broadly at, I would need to look specifically if there's any particular cases, but I would say yes, that would be the case.
In the North Louth, the case that's cited here, are you familiar with that?
Not the detail, I need to look over that.
Okay, are there any other matters on the agenda that people want to raise in regard to policy at this stage? Right, I think that's sufficient information for me in terms of the policy matters for today. And obviously we'll be exploring some of these in a little bit more detail when we get to specific detailed sessions. Thank you very much for your input today. I apologise for the technical problems. I hope that tomorrow can go a little bit more smoothly. If we can be here, and who's involved in the sessions tomorrow at 9:30, and be here at 9:15 if you want, or even earlier if you can, just so we can have a bit of testing and see how we get on. But bring any backup technology that you've got on USB sticks or whatever you require, extra laptops, and hopefully we can have a good couple of days at a landscape visual session.
Oh, can I just raise one point, and that was that last point in relation to North Louth was rather left hanging. So I think what Mr. Barrow is saying, look, I need to have a look at that. So we can probably pick that up in the landscape session. We can certainly deal with that in relation to submissions. I just don't want to lose the opportunity of coming back on that particular question, which is whether or not what we're saying is consistent with how reporters have dealt with it.
Okay, happy to explore that further, and we will do so. I'm absolutely sure of it. And I want to increase my understanding of that particular policy and how it might work. Okay, just finishing for today then. Thank you very much, everyone, and I will see some of you or many of you tomorrow. Thank you.